Good morning, everybody, and welcome to the Long Crime Trial Network. I'm Jesse Weber, and thanks so much for joining us. Well, I'm going to be with you for the next 3 hours with trial coverage for, you guessed it, the YNW Melly double murder trial. Closing arguments, they should be starting up shortly in that Broward County courtroom. It is a big day for both sides, but in the meantime, we really do have a lot to talk about, so I want to get you back up to speed. Now, as you know, or as you may know, the 24-year-old rapper, Jamell, he faces the death penalty in Florida for the 2018 shooting deaths of his two friends, Anthony Williams and Christopher Thomas Jr. The Murder on My Mind rapper claims that he and his co-defendant, Cortland Henry, that they were victims of a drive-by shooting on the day in question, but prosecutors say otherwise. They say that the evidence suggests the shots were fired from someone inside the vehicle, and that, of course, puts a wrench in the defendant's story. He did have one witness who testified on his behalf who said that they were actually together when they found out about the shooting, and he switched cars during the night. Now, the jury is going to have to consider all of this during their deliberations, which are slated to begin tomorrow. But as I said, we have to get through those closing arguments, the last attempt for each side to convince this jury or persuade this jury to their side. And that brings me, of course, to our eyes and ears in the courtroom. It's the morning. You know who we're going to bring in? Long Crime's very own Terry Austin. She is outside of that Broward County courthouse, or in the courthouse, outside the courtroom, I should say. Terry, good morning. It is good to see you. I feel like there's a lot of anticipation. You know, a lot of people are waiting for today. It's the end of the case. What's the atmosphere like right now?
Well, I do think there's a lot of anticipation, Jesse. I saw a lot of people going into the courtroom itself, so I think people are expecting to hear those closing arguments, and they want to know how everyone ties it all together. What is the prosecution going to say as far as some of the missing information, and absolutely what is the defense going to say? So I think both sides, the victims' families and obviously Melly's family, are all here, and I think they want to hear how the defense does this. We're also going to hear jury charges today, but I think the people are here for those closing arguments.
And just to be clear, you're saying people have showed up today maybe that weren't there during the earlier parts of the trial?
Yes, that's right. We have had packed courtrooms from time to time, but mostly I would say for the last week or so, it hasn't been packed. We haven't seen all of the individuals from the victims' families here. I understand they live a bit away from the courthouse, so that could be part of the issue, but I did see some of them coming in this morning, so I am expecting that it is going to be a full courtroom. We have seen Melly's mom, Jamie, come most every day, and some of the other family members. The brother is here. I have seen his sister as well, the mother, the grandmother. And there are people, there are fans who are here who are sitting on that side of the courtroom as well. So I would say that side of the courtroom is usually pretty full, but the other side, varies from day to day.
Let's talk about the jury instructions. Honestly, not the most engaging, not the most fun. We're waiting for the closing arguments. They are important. They're a roadmap for the jury to follow. Do we know if they're going to happen first? Are they going to happen between 9 a.m., 10 a.m. Eastern, or are they going to happen after the closing arguments?
Well, the last thing we heard from Judge Murphy is he's going to think about it. We do know that the defense wanted to have the statements made together, so he was suggesting that the statements be done first, the closing arguments be done first, so they could all be done on the same day at the same time. And then the prosecutor, we heard Ms. Bradley say she really wanted those jury charges first because she wanted that part to be resolved so she could make reference to it. So she preferred that the jury instructions come first. The judge did say he normally does those instructions first, but that he could do it either way depending on what the attorneys want. We don't know exactly how he's decided yet, whether the charges will come first or the closings, but everybody wants those closings to be close in time together so that jury can hear what one side says and then the other. And Jesse, as you know, the prosecution gets to go first, and then the defense goes, and then the prosecution gets an opportunity to do a rebuttal. The judge has given both sides 3 hours total.
That's what it was decided, because I know that they were asking for, 4 hours each, so it's going to be 3 hours in total for them, or 3 hours for their opening, 3 hours for their, the prosecution's going to have 3 hours for their closing argument, 3 hours for the rebuttal, or is it 3 hours in total for the prosecution, 3 hours in total for the defense?
The latter, Jesse. Each side will get 3 hours in total.
Okay.
And my understanding is that the prosecution is going to start with a 2-hour closing argument and then save 1 hour for her rebuttal. The defense gets the...
Jury instructions here? Good morning. Yes, sir. All right, so, and now yesterday we had a charge conference scheduled, and I was advised that it wasn't needed because all the issues had been resolved. Is that correct, Counsel?
Yes, Your Honor.
Yes, Your Honor.
All right, so I know there's some objections to the jury instructions which I ruled on the other day, but the form and substance of the jury instruction form might require ruling. Is that right?
That is correct.
All right, so are you ready to proceed?
Yes, Your Honor.
Defense?
Yes.
Need a minute to set up, or are you good?
Okay.
Gary?
Let's go.
Please roll the jury instructions.
Judge, there is just one correction on the jury instructions on page 25. It says, first paragraph, allegation in the information. It should be allegation in the indictment.
All right.
That's you. You see it?
Yeah. Do you want to just cross it off for the?
That's,
Sorry, if I just read it.
yes.
Okay.
All right, everybody ready?
Yes.
Yes? All right, bring jury in, please.
Your Honor, reading the instructions first.
Yes, ma'am.
Thank you.
Set. What says instructions?
But you're not going to consider reading them after closing?
If the parties agree to it, I do it. Otherwise, my practice normally is just to read it. I know it's discretionary for me to read it.
Obviously, we would ask that you read out.
Understood.
Jury entry?
Thank you. Please be seated. Let the record, excuse me, let the record once again reflect the presence of the defendant, Kevin, his counsel, his assistant attorney, as well as ladies and gentlemen. Ladies and gentlemen, a few minutes ago, I had my bailiff Gary leave on your chairs a set of the jury instructions. All right. It has up at the top on the first page, it reads, in the Circuit Court of the 17th Judicial Circuit in Fort Broward County, Florida, case number 18-001872, CFA, Judge John J. Murphy, State of Florida plaintiff versus Jamell, defendant, charged with the court. Does everybody have one of those? Yes? Yes. All right. So what we're going to do is read the instructions now. So we're going to start at page 3, where it says 3.1. Introduction to final instructions. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I am about to give you. 3.2, Statement of the Charge. Jamell Demons, the defendant in this case, has been accused in count 1 and 2 of the indictment of the crimes of first-degree murder. 7.1, Introduction to homicide. Jamell Demons is accused of first-degree murder in count 1 and count 2 of the indictment. First-degree murder includes the lesser crime of manslaughter. Both are unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. If you find Anthony Williams and/or Christopher Thomas were killed by Jamell Demons, you will then consider the circumstances surrounding the killing in deciding if the killing was first-degree murder or manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. Justifiable homicide. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. Excusable homicide. The killing of a human being is excusable and therefore lawful under any one of the following 3 circumstances. 1, when the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or 2, when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation. Or 3, when the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. An object not designed to inflict bodily harm may nonetheless be a dangerous weapon if it was used in a manner likely to cause death or great bodily harm. Great bodily harm means great, as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. I now instruct you on the circumstances that must be proved before Jamell Demons may be found guilty of first-degree murder or any lesser included crime. Count 1, 7.2, premeditated murder, first degree. To prove the crime of first-degree premeditated murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, Anthony Williams is dead. 2, the death was caused by the criminal act of Jamell Demons. 3, there was a premeditated killing of Anthony Williams. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. If you find that Jamell Demons committed first-degree premeditated murder, and you also find beyond a reasonable doubt that during the commission of the crime he actually possessed and discharged a firearm, you should find him guilty of first-degree premeditated murder with actual possession and discharge of a firearm. If you find that Jamell Demons committed first-degree premeditated murder And you will also find beyond a reasonable doubt that during the commission of the crime, he did actually possess a firearm. You should find him guilty of first-degree premeditated murder with actual possession. If you find that Jamell Demons committed first-degree premeditated murder, but did not actually possess or discharge a firearm during the commission of the offense, you should find him guilty only of first-degree premeditated murder. A firearm is defined as any weapon, including a starter gun, which is designed to or may readily be converted to expel a projectile by the action of an explosive, the frame or receiver of any such weapon, any firearm muffler or firearm silencer, any destructive device, or any machine gun. Actual possession of a firearm means the defendant A, had a firearm on his person, or B, had a firearm within immediate physical reach with ready access with the intent to use the firearm during the commission of the crime. If you find that Jamell Demons committed first-degree premeditated murder, and you also find beyond a reasonable doubt that during the commission of the crime he was a criminal gang member or associate as defined below, and the aforementioned activity was committed with the intent to benefit, promote, or further the interests of the criminal gang, you should find him guilty of first-degree premeditated murder in the first-degree premeditated murder in the first degree as a criminal gang member or associate. If you find that Jamell Demons committed first-degree premeditated murder, but find that he was not a criminal gang member or associate as defined below, you should find the defendant guilty only of first-degree premeditated murder. A formal or informal ongoing organization, association, or group that has one of its primary activities the commission of criminal or delinquent acts, and that consists of two or more persons who have a common name or common identifying signs, colors limited to terrorist organizations and hate groups. Ongoing means the organization was in existence during the time period charged in the indictment. Primary activities means criminal gang spends activity, although such activity need not be the only or even the most important activity in which the criminal gang engages. Criminal gang associate means a person who A, admits to criminal gang association, or B, meets any single defining criterion for criminal gang membership. Criminal gang member is a person who meets two or more of the following criteria. A, admits to criminal gang membership. B, adopts the style of dress of a criminal gang. C, adopts the use of a hand sign identified as used by a criminal gang. D, has a tattoo identified as used by a criminal gang. E, associates with one or more known criminal gang members. F, is identified as a criminal gang member by an informant of previously untested reliability, and such identification is corroborated by independent information. G, is identified as a criminal gang member by physical evidence. H, has been observed in the company of one or more known criminal gang members 4 or more times. Observation in a custodial setting requires a willful association. I, has authored any communication indicating responsibility for the commission of any crime by the criminal gang. Criminal gang activity means A, an activity committed with the intent to benefit, promote, or further the interests of the criminal gang, or for the purposes of increasing a person's own standing or position within a criminal gang. B, an activity in which the participants are identified as criminal gang members or criminal gang associates, acting individually or collectively to further any criminal purpose of a criminal gang. C, an activity that is identified as criminal gang activity by a documented, reliable informant. Or D, an activity that is identified as criminal gang activity by an informant of previously untested reliability, and such identification is corroborated by independent information. Electronic communication includes but is not limited to photographs, video, telephone, communications, text messages, facsimile, electronic mail messages, and instant messages, real-time communications with other individuals through the internet or other means. Count 2, 7.2, premeditated murder, first degree. To prove the crime of first degree, premeditated murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, Christopher Thomas is dead. 2, the death was caused by the criminal act of Jamell Demings. 3, there was a premeditated killing of Christopher Thomas. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. If you find that Jamell Demings committed first-degree premeditated murder, and you also find beyond a reasonable doubt that during the commission of the crime he actually possessed and discharged a firearm, you should find him guilty of first-degree premeditated murder with actual possession and discharge of a firearm. If you find that Jamell Demings committed first-degree premeditated murder, and you also find beyond a reasonable doubt that during the commission of the crime he did actually possess a firearm, you should find him guilty of first-degree premeditated murder with actual possession. If you find that Jamell Demings committed first-degree premeditated murder but did not actually possess or discharge a firearm during the commission of the offense, you should find him guilty only of first-degree premeditated murder. A firearm is defined as any weapon, including a starter gun, which is designed to or may readily be converted to expel a projectile by the action of an explosive. The frame or receiver of any such weapon, any firearm muffler or firearm silencer, any destructive device, or any machine gun. Actual possession of a firearm means the defendant A, carried a firearm on his person, or B, had a firearm within immediate physical reach with ready access with the intent to use the firearm during the commission of the crime. If you find that Jamell Demings committed first-degree premeditated murder, and you also find beyond a reasonable doubt that during the commission of the crime he was a criminal gang member or associate as defined below, and the aforementioned activity was committed with the intent to benefit, promote, or further the interests of the criminal gang, you should find him guilty of first-degree premeditated murder in the first degree as a criminal gang member or associate. If you find that Jamell Demings committed first-degree premeditated murder, but find that he was not a criminal gang member or associate as defined below, you should find the defendant guilty only of first-degree premeditated murder. Criminal gang means a formal or informal ongoing organization, association, or group that has one of its primary activities the commission of criminal or delinquent acts, and that consists of 3 or more persons who have a common name or common identifying signs, colors, or symbols, including but not limited to terrorist organizations and hate groups. Ongoing means that the organization was in existence during the period charged in the indictment. Primary activity means that a criminal gang spends a substantial amount of time engaged in such activity, although such activity need not be the only or even the most important activity in which the criminal gang engages. Criminal gang associate means a person who A, admits to criminal gang association, or B, meets any single defining criterion for criminal gang membership. Criminal gang member is a person who meets two or more of the following criteria. A, admits to criminal gang membership. B, adopts the style of dress of a criminal gang. C, adopts the use of a hand sign identified as used by the criminal gang. D, has a tattoo identified as used by a criminal gang. E, associates with one or more known criminal gang members. F, is identified as a criminal gang member by an informant of previously untested reliability, and such identification is corroborated by independent information. G, is identified as a criminal gang member by physical evidence. H, has been observed in the company of one or more known criminal gang members 4 or more times. Observation in a custodial setting requires a willful association. I, has authored any communication indicating responsibility for the commission of any crime by the criminal gang. Criminal gang-related activity means A, an activity committed with the intent to benefit, promote, or further the interests of the gang, or for purposes of increasing a person's own standing or position within the gang. B, an activity in which the participants are identified as criminal gang or criminal gang associates acting individually or collectively to further any criminal purpose of a criminal gang. C, an activity that is identified as criminal gang activity by a documented reliable informant. Or D, an activity that is identified as criminal gang activity by an informant of previously untested reliability, and such identification is corroborated by independent information. Electronic communication includes, but is not limited to, photographs, video, telephone communications, text messages, facsimile, electronic mail, and instant message real-time communications with other individuals through the internet or other means. 3.4. When there are lesser included crimes or attempts. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crimes of which he is accused, there may be evidence that he committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crime indicated in the definition of murder in the first degree is manslaughter. Count 1, 7.7, manslaughter. To prove the crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. 1, Anthony Williams is dead. 2, Jamell Devens intentionally committed an act or acts that caused the death of Anthony Williams. 4, Jamell intention to harm. That violation is an act, or if the killing was either justifiable or excusable, as I have previously instructed you. Those explanations of justifiable homicide and excusable homicide are in Instruction 7.1, Introduction to Homicide. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. To procure means to persuade, induce, prevail upon, or cause a person to do something. If you find that Jamell Devens committed manslaughter, and you also find beyond a reasonable doubt that during the commission of the crime he actually possessed a firearm, you should find him guilty of manslaughter with actual possession of a firearm. If you find that Jamell Devens committed manslaughter but did not actually possess a firearm during the commission of the offense, you should find him guilty only of manslaughter. A firearm is defined as any weapon, including a starter gun, which is designed to or may readily be converted to expel a projectile by the action of an explosive. The frame or receiver of any such weapon, any firearm muffler or firearm silencer, any destructive device, or any machine gun. Actual possession of a firearm means the defendant A, carried a firearm on his person, or B, had a firearm within immediate physical reach with ready access with the intent to use the firearm during the commission of the crime. If you find that Jamell Demings committed manslaughter, and you also find beyond a reasonable doubt that during the commission of the crime he was a criminal gang member or associate as defined below, and the aforementioned activity was committed with the intent to benefit, promote, or further the interests of the criminal gang, you should find him guilty of manslaughter as a criminal gang member or associate. If you find that Jamell Demings committed manslaughter, but find that he was not a criminal gang member or associate as defined below, you should find the defendant guilty only of manslaughter. Criminal gang means a formal or informal ongoing organization, association, or group that has one of its primary activities the commission of criminal or delinquent acts, and that consists of 3 or more persons who have a common name or common identifying signs, colors, or symbols, including but not limited to terrorist organizations and hate groups. Ongoing means that the organization was in existence during the time period charged in the indictment. Primary activities means that the criminal gang spends a substantial amount of time engaged in such activity, although such activity need not be the only or even the most important activity in which the criminal gang engages. Criminal gang associate means a person who A, admits to criminal gang association, or B, meets any single defining criterion for criminal gang memberships. Criminal gang member is a person who meets 2 or more of the following criteria. A, admits to criminal gang membership. B, adopts the style of dress of a criminal gang. C, adopts the use of a hand sign identified as used by a criminal gang. D, has a tattoo identified as used by a criminal gang. E, associates with 1 or more known criminal gang members. F, is identified as a criminal gang member by an informant of previously untested reliability, and such identification is corroborated by independent information. G, is identified as a criminal gang member by physical evidence. H, has been observed in the company of 1 or more known criminal gang members 4 or more times. Observation in a custodial setting requires a willful association. I, has authored any communication indicating responsibility for the commission of any crime by the criminal gang. Criminal gang-related activity means A, an activity committed with the intent to benefit, promote, or further the interests of a criminal gang, or for the purpose of increasing the person's own standing or position within a criminal gang. B, an activity in which the participants are identified as criminal gang members or criminal gang associates acting individually or collectively to further any criminal purpose of a criminal gang. C, an activity that is identified as criminal gang activity by a documented, reliable informant. Or D, an activity that is identified as criminal gang activity by an informant of previously untested reliability, and such identification is corroborated by independent information. Electronic communication includes, but is not limited to, photographs, video, telephone communications, text messages, facsimile, electronic mail messages, and instant messages, real-time communications with other individuals through the internet or other means. Count 2, 7.7, manslaughter. To prove the crime of manslaughter, the state must prove the following 2 elements beyond a reasonable doubt. 1, Christopher Thomas is dead. 2, Jamell Demings intentionally committed an act or acts that caused the death of Christopher Thomas. 4, Jamell Demings intentionally procured an act that caused the death of Christopher Thomas. Every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention of harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. The explanations of justifiable homicide and excusable homicide are in instruction 7.1, Introduction to Homicide. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, or excusable, and which caused death. To procure means to persuade, induce, prevail upon, or cause a person to do something. If you find that Jamell Demings committed manslaughter, and you also find beyond a reasonable doubt that during the commission of the crime he actually possessed a firearm, you should find him guilty of manslaughter with actual possession of a firearm. If you find that Jamell Demings committed manslaughter, but did not actually possess a firearm during the commission of the offense, you should find him guilty only of manslaughter. A firearm is defined as any weapon, including a starter gun, which is designed to or may readily be converted to expel a projectile by the action of an explosive, the frame or receiver of any such weapon, any firearm muffler or firearm silencer, any destructive device, or any machine gun. Actual possession of a firearm means the defendant A, carried a firearm on his person, or B, had a firearm within immediate physical reach with ready access with the intent to use the firearm during the commission of the crime. If you find that Jamell Demings committed manslaughter, and you also find beyond a reasonable doubt that during the commission of the crime he was a criminal gang member, associate as defined below, and the aforementioned activity was committed with the intent to benefit, promote, or further the interests of the criminal gang, you should find him guilty of manslaughter as a criminal gang member or associate. If you find that Jamell Demings committed manslaughter, but find that he was not a criminal gang member or associate as defined below, you should find the defendant guilty only of manslaughter. Criminal gang means a formal or informal ongoing organization, association, or group that has one of its primary activities the commission of criminal or delinquent acts, and that consists of 3 or more persons who have a common name or common identifying signs, colors, or symbols, including but not limited to terrorist organizations and hate groups. Ongoing means that the organization was in existence during the time period charged in the indictment. Primary activities means that the criminal gang spends a substantial amount of time engaged in such activity, although such activity may not be the only or even the most important activity in which the criminal gang engages. Criminal gang associate means a person who A, admits to criminal gang association, or B, meets any single defining criterion of criminal gang membership. A criminal gang member is a person who meets 2 or more of the following criteria. A, admits to criminal gang membership. B, adopts the style of dress of a criminal gang. C, adopts the use of a hand sign identified as used by a criminal gang. D, has a tattoo identified as used by a criminal gang. E, associates with 1 or more known criminal gang members. F, is identified as a criminal gang member by an informant of previously untested reliability, and such identification is corroborated by independent information. G, is identified as a criminal gang member by physical evidence. H, has been observed in the company of 1 or more known criminal gang members 4 or more times. Observation in a custodial setting requires a willful association. I, has authored any communication indicating responsibility for the commission of any crime by the criminal gang. Criminal gang-related activity means A, an activity committed with the intent to benefit, promote, or further the interests of a criminal gang, or for the purpose of increasing a person's own standing or position within a criminal gang. B, an activity in which the participants are identified as criminal gang members or criminal gang associates, acting individually or collectively to further any criminal purpose of a criminal gang. C, an activity that is identified as criminal gang activity by a documented, reliable informant. Or D, an activity that is identified as criminal gang activity by an informant of previously untested reliability, and such identification is corroborated by independent information. Electronic communication includes, but is not limited to, photographs, video, telephone communications, text messages, facsimile, electronic mail messages, and instant messages, and instant message real-time communications with other individuals through the internet or other means. 3.5a, principles. If the defendant helped another person or persons attempt to commit a crime, the defendant is a principal and must be treated as if he had done all the things the other person or person did if, 1, the defendant had a conscious intent that the criminal act be done, and 2, the defendant did some act or said some word which was intended to and which did incite, cause, encourage, assist, or advise the other person or persons to actually commit or attempt to commit the crime. To be a principal, the defendant does not have to be present when the crime is committed or attempted. 3.7, plea of not guilty, reasonable doubt, and burden of proof. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the indictment through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving a crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, or one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. 3.9, weighing the evidence. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted, as well as what they said. Some things you should consider are: 1, did the witness seem to have an opportunity to see and know the things about which the witness testified? 2, did the witness seem to have an accurate memory? 3, was the witness honest and straightforward in answering the attorney's questions? 4, did the witness have some interest in how the case should be decided? 5, does the witness's testimony agree with the other testimony and other evidence in the case? 6, has the witness been offered or received any money, deferred treatment, or other benefit in order to get the witness to testify? 7, had any pressure or threat been used against the witness that affected the truth of the witness's testimony? 8, did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? 9, has the witness been convicted of a felony? Whether the state has met its burden of proof does not depend upon the number of witnesses it is called or upon the number of exhibits it is offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or his opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. You must consider the testimony of some witnesses with more caution than others. For example, a witness who hopes to gain more favorable treatment is, in his own case, may have a reason to make a false statement in order to strike a good bargain with the state. This is particularly true when there is no other evidence tending to agree with what the witness says about the defendant. So while a witness of that kind may be entirely truthful when testifying, you should consider his testimony with more caution than the testimony of other witnesses. However, if the testimony of such a witness convinces you beyond reasonable doubt of the defendant's guilt, or the other evidence in the case does so, then you should find the defendant guilty. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the court. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusions about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. 3.9, Section A, defendant not testifying. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove his innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by his decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. 3.10, rules for deliberation. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. 1, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. 2, this case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of exhibits and evidence and these instructions. 3, this case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. 4, remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. 5, your duty is to determine if the defendant has been proven guilty or not in accord with the law. 6, whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. 7, your verdict must not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. 3.11, cautionary instruction. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. 3.12, verdict. You may find the defendant guilty as charged in the indictment or guilty of such lesser included crime as the evidence may justify or not guilty. If you return a verdict of guilty, it should be for the highest offense which has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then, of course, your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, the necessary forms of verdict have been prepared for you. They are as follows. 3.12, A, subsection A, single defendant, multiple counts. A separate crime is charged in each count of the indictment, and although they have been tried together, each crime and the evidence applicable to it must be considered separately. and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crime charged. The verdict. I don't believe you have that in the package. I have it here. The verdict starts out and has up at the top the style of the case. That's what we refer to as the style of the case. It reads, in the Circuit Court of the 17th Judicial Circuit in Fort Broward County, Florida, case number 19-001872, CF-10A, Judge John J. Murphy, State of Florida, plaintiff versus Jamell Demons, defendant, verdict. Count one. We, the jury, find as follows as to the defendant in this case. And it goes on, parentheses, check only one. A, the defendant is guilty of murder in the first degree as charged in the indictment. B, the defendant is guilty of manslaughter, a lesser included offense. C, the defendant is not guilty. It goes on further. It says, if you find the defendant guilty of any of the crimes listed above, you must answer the following questions. 1. During the course of the crime committed, did the defendant, Jamell Demons, actually possess a firearm? Then you check the appropriate box, either yes or no. It goes on, paragraph 2. During the course of the crime committed, did the defendant, Jamell Demons, actually discharge a firearm? You check the appropriate box, either yes or no. Question 3. During the course of the crime committed, did the defendant, Jamell Demons, actually inflict death or great bodily harm to Anthony Williams as a result of discharging a firearm in his possession? Again, you check the appropriate box, either yes or no. The verdict form goes on. Question 4. Did the state prove beyond a reasonable doubt the defendant committed the crime for the purpose of benefiting, promoting, or furthering the interests of the criminal gang? Again, you check the appropriate box, either yes or no. And then it goes on and says, so say we all this blank day of blank AD 2023 at Fort Lauderdale, Broward County, Florida. There's a place for the foreperson to sign and date the verdict form. Then there's a second verdict form for count 2. And again, it has the style of the case up at the top, and it reads, verdict, count 2. We, the jury, find as follows as to the defendant in this case, check only one. A, the defendant is guilty of murder in the first degree as charged in the indictment. B, the defendant is guilty of manslaughter, a lesser included offense. C, the defendant is not guilty. Then goes down further and says, if you find the defendant guilty of any of the crimes listed above, you must answer the following questions. 1, during the course of the crime committed, did the defendant, Jamell Demons, actually possess a firearm? Again, you check the appropriate box, either yes or no. Question 2, during the course of the crime committed, did the defendant, Jamell Demons, actually discharge a firearm? Again, you check the appropriate box, either yes or no. Question 3, during the course of the crime committed, did the defendant, Jamell Demons, actually inflict death or great bodily harm to Christopher Thomas as a result of discharging a firearm in his possession? And then again, you check the appropriate box, either yes or no. And it goes on. Question 4, did the state prove beyond a reasonable doubt the defendant committed the crime for the purpose of benefiting, promoting, or furthering the interests of the criminal gang? And again, you check the appropriate box, either yes or no. It goes on further, it says, so say we all this blank day of blank AD 2023 at Fort Lauderdale, Broward County, Florida. And again, there's a spot at the bottom for the foreperson to print their name and sign and date the verdict. Is there any objection to the instructions as published in open court by the state?
Yeah.
By the defense?
No, sir.
Ladies and gentlemen, we're going to go to the second page of these instructions. It's called Closing Argument 2.7, and it reads as follows. The state and the defendant have now rested their case. The attorneys now will present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has given its closing argument. Madam State?
Yes, sir. Ladies and gentlemen, at this time, I can get up here before you and say the defendant is guilty of murder in the first degree. I can say that because you have sat through 16 days of testimony, and because back when you first started here, some of you as early as April 10th, you agreed to follow the law. And the law is clear that this defendant committed 2 counts of first-degree murder. I now have the opportunity to explain all of the evidence, because sometimes you get it piecemeal. What does this piece mean? What does this mean? So this is where we have the opportunity to show you how everything fits together. So I want to start, but I also want to thank you for showing up. You received a summons. You complied with it. You came to the courthouse, and you decided to do your civic duty. We appreciate that. As I said before, we cannot do our jobs, and this judicial system does not work without you being here.
Counsel, can I see a side vote?
Yes, ma'am.
Ladies and gentlemen, I just received a message that one of your members needs.
What's up, y'all?
Take a short recess. Do not discuss the case. Don't form any opinion about the case. Don't allow anyone to discuss the case in present. Please just give your notepads and the jury instructions on your chairs. Thank you.
Getting down to, she said she about to explain it. Now they need a recess. Oh. Well, y'all, shoot. I ain't feeling the best, but we gonna thug it out.
Gentlemen, can you look at
Thug it out today.
Good. We're in recess. Thank you.
They on a recess. Oh man, I know they happy. I'm gonna keep it real. I know the jury is excited. Like, let's get this thing popping. Well, I mean, after this, we just we gotta sit back and wait, right? Or I don't know. We gotta sit back and wait. But to me, this is what we all been waiting for real. You know what I mean? Oh yeah! This is what we all been waiting for. Now she get to piece together all this evidence and weave it into a story. And I mean, she's hoping a cohesive story. But I'm wore out. This trial done wore me out, y'all. I'm sick of these short breaks, these sidebars. But hold on, let me see what's going on.
Network, everybody. I'm Jesse Weber, and thanks so much for joining us. So closing arguments have just begun in Broward County, Florida for the double murder trial against rapper Jamell, better known as YNW Melly. The 24-year-old faces the death penalty for the 2018 shooting deaths of his 2 friends. And right now, Christine Bradley is giving the state's closing arguments. We don't want you to miss any minute. Let's go right into that courtroom.
Ladies and gentlemen, at this time, I can get up here before you and say the defendant is guilty of murder in the first degree. I can say that because you have sat through 16 days of testimony, and because back when you first started here, some of you as early as April 10th, you agreed to follow the law. And the law is clear that this defendant committed 2 counts of first-degree murder. I now have the opportunity to explain all of the evidence, because sometimes you get it piecemeal. What does this piece mean? What does this mean? So this is where we have the opportunity to show you how everything fits together. So I want to start, but I also want to thank you for showing up. You received a summons. You complied with it. You came to the courthouse, and you decided to do your civic duty. We appreciate that. As I said before, we cannot do our jobs, and this judicial system does not work without you being here.
Counsel, can I see side vote?
All right, so they're going to go to a quick sidebar there. Let's take some analysis of what we're seeing in that short minute. I'm here with trial attorney Megan Whiteside, and also joining us is Deputy Public Defender Philip Dubé from LA County, who's appearing in his personal capacity. Philip, good to see you. I'm going to start with you. So that was so short, but I did think it was interesting because so many times, particularly during the prosecution's case, you don't know where they're going or why certain evidence is introduced or how it ties back to this, particularly with all of that cell phone data. Now is their time to explain it. How do they explain it in a way for the jury to understand and that is compelling?
Well, the first thing you want to do is establish the theory, and that is whether or not it's a first, second, or capital murder. And then they're going to go through the elements of each crime to show how they've met their burden beyond a reasonable doubt. They're also going to probably try to weave in this idea of what the defense is going to argue to soften the blow of whatever reasonable doubt the defense is trying to raise. Prosecutors notoriously do that. They try to take the wind out of defense counsel's sail before they've had an opportunity to get up and address the jury. That's a very common ploy as well. But most important, they're going to go through the law. They're then going to weave in all the testimony that came in to prove each element. And I think their most compelling evidence right now is the absence of defense evidence. I was shocked, Jesse, and I don't know if Megan agrees, that they basically put nobody on to counter the ballistics and all the trajectory evidence, or at a minimum to counter what the coroner or the medical examiner found. Put on your own private pathologist, but without that, I think this kid's in trouble. The issue here is whether or not he's condemned or gets life.
Okay, well, first of all, we just got word that they went on a bathroom break. Why they didn't do that right before the closing arguments instead of waiting 1 minute in, I don't know. But Megan, I'm going to throw it to you. So again, the argument, Megan, would be that they only called this one witness, Adrian Davis, because he said Melly wasn't even in the car, the crime scene. He wasn't there. And so maybe they feel they don't have to show any other kinds of experts. I will say it was surprising. We thought they were going to call experts. Megan, what do you think?
I think it's a gutsy call, and it's going to come down to the credibility of that witness, because if the jury finds that witness to be biased, I mean, this was one of the defendant's friends saying, yeah, my friend was in that car and he got out of the car and got into the Mitsubishi with me. It's going to come down to his credibility. The defense perhaps could not get favorable expert testimony to counter the government's ballistics evidence and autopsy findings. We don't know. And we're, Monday morning quarterbacking or Thursday morning quarterbacking here, but I think that they clearly believe their one witness was strong enough to prove the government has the wrong guy.
Do you think it's, Philip, a little bit risky to bank it all on one person?
With a capital R, frankly. And the reason why, remember, correct me if I'm wrong, but don't they have him on video getting into that Jeep?
They do.
They have him in the car. They have him.
Well, he said, this witness said that at one point he switched cars. They drove off and then he went into a different car.
Jesse, what is it with these young kids where all of a sudden they swap cars, they get out, one person that becomes a passenger, one becomes a driver, then they switch cell phones, somebody else is holding the phone, and then coincidentally they make incriminating text messages. I just don't think a jury is going to buy it. The fact that he is in that car, and then you have somebody saying, no, he wasn't, the jury's eyes will not deceive them when they see him on video getting in and out of that Jeep. I think he's done, frankly. I do.
So Megan, this this is a good point, and I want to bring this up to you. And the point that I want to make is, and Phil raises it well, is that the defense's rationale for everything is it wasn't him. It wasn't him making those text messages. It wasn't him using that phone. He wasn't in that car. Instead of maybe saying, okay, that was his phone, but maybe, you know, the accuracy of this data we can question, or yeah, maybe he said, I did that, in reference to the shooting, but maybe he was just, you know, trying to say it to I don't know, for street cred or something like that, or take ownership of, or he was joking. They keep saying it wasn't him, or trying to suggest it wasn't him. Is that maybe not the best strategy?
I think it might backfire on them, right? Because a coincidence upon a coincidence upon a coincidence, like when all of these things keep lining up against the defendant, to just blanketly deny all of them, I think lessens the credibility of the defense's theory of the case. Like you said, if you can admit to at least one inconsequential part of what's going on here, but argue that the government hasn't linked up everything else, I think it helps your credibility as the lawyer arguing the case. I think, though, in addition to banking on, you've got the wrong guy, it wasn't me in the car because I left, I think their argument on premeditation, they may be trying to prevent a first-degree murder charge, recognizing they've got an uphill battle against the government. We'll see.
Well, that's a good point. So, Philip, I was saying to Megan before that when you look at the video of him going into that car, it doesn't look like a guy who's about to commit double murder. I mean, but then again, we've seen people before who commit murders out of nowhere. And there's a question of, did something maybe happen in that ar that, if you believe he's the shooter, allegedly caused him to do that and fire upon his two friends? Now, and we know that motive is not an element of a crime, but it does help tell the story. And we're all trying to understand why he would have killed his two friends in cold blood like that. I wonder if that's going to give the jury pause at all.
Well, which is precisely why I would have put on a completely different defense. This should have focused on being a drive up by some rival gang members, pointing a gun. Jamell sees it, and before they fire, he fires first, just sort of indiscriminately, and before you know it, you got bullets flying everywhere and killed his fellow passengers. I think that would have been a greater defense, and frankly, I think he could have hung that jury, assuming it gets that far, with that type of reasonable doubt, but now they put nobody on. They didn't even call a trajectory, a ballistics, or a bullet pathway expert to help counter what the prosecution put in evidence. So if the jury buys what the prosecution said as to trajectory evidence, I think this kid, frankly, not to sound like I'm jumping the shark, is going down. I do.
Well, let's talk about that for a second here, Megan, because if he is convicted, it will be this jury who has to decide life or death. And just because they convict him doesn't necessarily mean it's a death penalty. Then again, they might. I mean, this is a death penalty qualified jury. What goes into that?
Well, it's an interesting, the penalty phase is going to be...
So here's what we start with. Detective Moretti has an investigation that starts on October 26th of 2018. We have two dead bodies that are dropped off at Memorial Miramar. Christopher Thomas and Anthony Williams. You have Cortland Henry, who's lying about anything and everything. He's lying about the location of where it happened. He's lying about when it happened. He's lying about Mr. Demmons, the defendant, being in the car at any point that evening. Totally omits that. We then have the cover-up that begins. So the question is why? Why does there need to be cover-up? Because there was a murder that was committed, ladies and gentlemen, that's why. There were two murders that were committed. And so from here, we're going to talk about and explain what we have, right? So Detective Moretti and the Miramar Police Department have to answer 4 questions. Who, what, when, and where? And so for the where, I want to start with, where did the lethal shots come from? And let's start and focus on that part of the investigation. So the where, we looked at Chris Williams. If you remember, Sergeant Williams came in and testified and showed you how Blue Star works, showed you how shooting reconstructions are done with the trajectory rods. This explained how Miramar had made a good attempt, but they lacked training. So he came in and went through and is able to explain, as an expert in shooting reconstruction, what happened in this car. So we're going to start on the trajectory routes. If you recall, on the outside, the most important aspect of the ones on the outside of the car is they show that this was not a drive-by. That they're coming in at 90 degrees, that there's no keyholing. If you remember, you learned about keyholing, that would be an angle of entry on that. So he then showed you the blue star. And if you recall, ladies and gentlemen, this chemical reacts no matter how many years later, no matter what attempt at cleanup is done. The chemical is still going to react to the presence of the blood. So then you have that reaction. And that reaction, ladies and gentlemen, tells you that someone is sitting in this seat. Because, as Detective Williams illustrated, it's where the blue star isn't. So there is no blood. There's no blood where someone's would have been sitting. There's no blood where their legs would have been, and you can see on the V that's indicated on that. And there's no blood on the back of the seat. So, ladies and gentlemen, what does that tell you? The killer was sitting there. And there's no blood because something was blocking it from getting onto that area of the car. So what do we know as well from this car? We know that there was also that this door was closed. How can that be said? Because, ladies and gentlemen, the blue star here shows that this door was shut because there was blood on this door handle. You have from this as well the headliner. So the headliner shows directionality. The headliner shows the way Anthony Williams' head was positioned when he was shot. That's one aspect of it. That DNA that was tested is all Anthony Williams, but we'll get to that. So the DNA, very strong support. 51.2 septillion times more likely to be that of Anthony Williams than any unrelated individual in the world. That was from Kurt Rhodes. If you recall, he was the expert on DNA. He told you and taught you how DNA is done, how everything works. So now, putting those two things together, you can say, and the evidence shows, Anthony Williams, the way his head was in that Jeep, is that he is sitting in this front passenger seat, and as you can see, all the blood is dripping down the back of the seat. That tells you, ladies and gentlemen, and from the angle of entry when we get to the medical examiner's information, that his head was right here. So then we have one of the things that Detective Williams relied upon was the shirt of Cortland Henry. If you recall, there is a spot of blood on the front of the shirt. That blood, as Kurt Rhodes then told you, belongs to Anthony Williams. What does that tell you, ladies and gentlemen? That during the course of this shooting, Cortland Henry has his back against the driver's seat and is driving wearing this shirt when the shooting occurs. You know from that he is not the shooter. Why? Because if he was the shooter, the angle to get that wouldn't have the blood on the front of his shirt. It would have it coming across the driver's side and towards the side of his shirt, not the front. So on here you have the blowback coming there, and that's, again, 32.2 septillion times more likely to be the DNA of Anthony Williams. So then we have the back of the shirt. And so if you recall, the blood on the back of the shirt is right here. And that blood, Christopher Thomas, a single source profile. So what does that tell you, ladies and gentlemen? That tells you that Cortland Henry didn't fire the fatal shot for Christopher Thomas. Here's why. That blood is coming from Mr. Thomas when he is shot. The blood's only moving like that, as you heard from Sergeant Williams, when there is a pulse, when there is pressure. Remember the garden hose analogy that he used and talked about? That's when you're getting the blood that's going to be coming out of the body. And on that, so from there, you know, Cortland Henry is ducked over and flinching away from Christopher Thomas. So he cannot get that shot on Christopher Thomas from where he is seated in the driver's seat. Even if he was in the back seat, let's argue that for a second. To get the blood there, he would have to have been completely turned facing backwards to Mr. Thomas and then turned and shot over his shoulder to get blood on the back of his shirt. That's not reasonable inside of a car. What is reasonable is that he's driving, the shot happens to Anthony Williams in the back of the head, blood gets on the front of his shirt. He flinches, comes down, shot happens to Christopher Thomas, blood gets on the back of his shirt. So that was the other aspect that we learned from Anthony Williams, because there was the entrance and the exit wound. So from there, ladies and gentlemen, you can tell, again, the side-to-side orientation of the head, because that front passenger window is blown out. That tells you that his head was not upright, but it was laying over to the side, because if you recall, the entrance on Mr. Williams is back behind his left ear, and the exit is up here in his hairline. If he was sitting up and awake and knew what was going on, you would expect to find a projectile in the headliner and the roof of that Jeep. But you don't. Instead, you know, based on his head angle, that it goes out the window, blows out the glass. For Christopher Thomas, he is in the rear. So what do you know about Christopher Thomas's wound? That it's coming in at almost 90 degrees on the left side of his face, and that there is stippling. You learned about stippling, the imprint of unburnt gunpowder into the skin of a living human being. Powder tattooing, it's also called. So on Christopher Thomas, you learned from Sergeant Williams, as well as from the medical examiners, that the firearm that inflicted that wound was approximately 3 inches to no more than 3 feet. Sergeant Williams said his estimation is no more than 12 inches away. And so why is that important? Let's go back and argue the Cortland Henry. If Cortland Henry was making these shots from the driver's seat, you would expect Anthony Williams to be covered in stippling, because they're that much closer and nothing would be blocking or impeding that shot. But if the shot is instead coming from the rear passenger side, you're not going to have that same stippling on Anthony Williams, because the seat's in the way. Cortland Henry, there is nothing blocking it, so you have the stippling. So ladies and gentlemen, that's one of the things that you would notice, and the differences that show that why it could not have been Cortland Henry in the driver's seat with this weapon. We know it can the backseat passenger, it could have been, because there is stippling. If it was the backseat passenger was shot by the driver, you wouldn't see that pattern of stippling, because they couldn't get close enough to make that pattern in that imprint. So then we have all the drive-by on the trajectory rods that we talked about briefly. But this one is important because this is talking about strike K. So why is strike K important, right? Strike K comes in and hits the front of the rear door. That tells you that that door was open when that drive-by was staged. Because as you heard from Sergeant Williams, if this was actually a drive-by, this is what you would have seen. Strikes coming in at different angles, at obtuse angles. There would be angles of entry that would show either a pattern of speeding up or slowing down. But instead, you have them coming in at 90 degrees. And that goes for the front, on the driver's side door, the rear driver's side door, and then you have stripe K going across. And remember, this is Chris Carter took this picture that shows you where stripe K impacted this door. If this door had been closed, you would expect it to be going into the speaker. That's where you would expect it if it had been a closed door. That's not what happened. Also, if that had happened during a drive-by, whoever was sitting in that rear driver's side passenger seat would have had a projectile right through their knees. That was the path of that bullet. Talking about as well on the driver. If you recall, ladies and gentlemen, projectiles are found underneath the brake pedal. You don't see any injuries on Mr. Henry. He got out of that car too. So the shots from the back of the car, same angle of entry. They're not coming from the side. They're not coming in like there's any difference. So now, ladies and gentlemen, I have to talk about the medical examiner's information. I know it's difficult. So what I'm going to do is I'm going to put a picture up briefly, then I'm going to move to a blank slide to talk about it. So everyone, I'm not trying to traumatize anyone. It's part of the case and it's evidence, so I apologize. So as you've learned, Anthony Williams' autopsy was conducted by Dr. McDougall. Dr. McDougall, if you remember, had COVID. She came in and testified. So again, we have Anthony Williams. What did you learn during the course of Anthony Williams' autopsy? You learned that this is one of 3 times that Dr. McDougall could ever testify what was the fatal shot and which shots were post-mortem. And so I'm going to move on, and the next picture is going to show the fatal shot. Again, A is the entry wound, and E is the exit wound. And again, that shows the angle in which his head was positioned. And also it shows the lack of stippling, showing that that firearm was further away than that of from the wound that was inflicted on Christopher Thomas. So then I'm going to show you for comparison the difference with the post-mortem, where it's white, there's no hemorrhaging, there's no signs of life, body bleeding on these wounds. And these are the ones, if you recall, to his shoulder and to his torso. And so the one from his torso, which is B, came in through the side of the car and was into his body. And if you recall, the one that's like C came from one of the shots through the back of the car and into his shoulder. Moving on to Dr. Sodders with Christopher Thomas. As to Christopher Thomas, you learned about the stippling and the pattern that's on them. You learned the distance determination, and you learned that the wound through his head was the one that caused his death. And that was the one for which he was alive. You learned that when you're stippling, those are those tiny black implanted bits of gunpowder. So if you recall from George Bello, he drew the cone. You have a firearm, and as the parts from the firearm that are expelled, you have the projectile that goes forward, and then you have the cloud that gets increasingly bigger as it travels away from the muzzle of the gun. The example, if you take a handful of dust, sand, and a golf ball. You learn the golf ball is going to go the farthest because it has the most mass. It has the most weight to it. So the most energy can be transported to it. The golf ball is like your bullet. The sand is your unburnt powders of gunpowder. It's going to travel, not as far, but it has more mass, so more energy can be transferred to it than that of the dust. The dust falls out quickly. That's why we can say it's not 3 inches, but that's why they can say it's less than 3 feet from the medical examiner's perspective. So going to the wounds on his back. Again, no signs whatsoever of any blood, hemorrhaging in any of those wounds. There are projectiles that intersect his lungs. You heard Dr. Souther testify that the lungs bleed profusely if a person is alive. So, ladies and gentlemen, from all of this, at this point, the state has established that there was someone in that rear seat. The someone who is in that rear seat is the person who committed this murder. And so now the question is who? So I'm going to show you now why the state has proven who was Jamell Dennis. So we have the studio video. This is going to go through, and you can track the defendant wearing that lyrical lemonade sweater all the way out to the Jeep, where he gets in the spot the murderer sat in. It's important to notice, ladies and gentlemen, that phone, always, always, always in his hand. He doesn't let go of it, it's still in his right hand as he's going to go get in that rear driver's side seat. Same with that satchel. And recall, ladies and gentlemen, that satchel and the one that you see Christopher Thomas wearing are never recovered. So they were taken out of the car by the defendant. So let's talk about T-Mobile records and the phones and why this is important, okay? So the question is, are the phones themselves, do they know where they are? And then does the network know where the phone is? So this, ladies and gentlemen, is one of the exhibits that was put in, and this is the phone of Mr. Devens at 3:18 a.m. If you will notice that there is right here a camera icon, and that is located at 805 Northeast 4th Avenue, because that's the camera from the studio that you just watched. And the blue pin is where the network thinks the phone is. Is it perfectly precise? No. But is it accurate? Yes, within a football field, right? We learned that less than 78 meters is the range on those bands for the timing advance. But this isn't the timing advance. This is where the network thinks the phone is. Ladies and gentlemen, the phones work. You know the phones work because in your daily life, when you need to go anywhere, you go into a mapping app and you put an address in. You don't have to know where you are to get somewhere because the phone knows where you are. These are things that you use on a daily basis. It's common sense. The phones work because you've used them. We've relied on them for years to show exactly how to get someplace. Look, in a populated area like this where there's multi-story buildings, okay, maybe it's a little bit more difficult to say precisely where a phone is. You can order a pizza by sending a drop pin. The phones work, ladies and gentlemen. We rely on them in our everyday life. So let's go and talk about the T-Mobile and the Sprint records. And so, ladies and gentlemen, what I'm putting up here is what I believe the evidence reflects. This doesn't go back with you. You don't get to take a copy of this into the back, but this is all things that are in evidence. This is a summary of them. So these are all the phone numbers that were in use in October of 2018. I am not suggesting they are still being used by these individuals. So at this point, the state has established, based on the business records from Sprint, Christopher Thomas, 772-713-2341. Anthony Williams, 954-248-9081. Mr. Devens, 772-713-9807. Cortland Henry, 561-7 720-3210. Jamie King, the mother of Mr. Demmons, 772-501-6942. Jameson Francois, track, the manager, 954-376-9158. Frederick Givens, the Louisiana-based rapper who lived the next community over, 225-529-5054. And then Dontavius Withers, one of the other individuals in the red Mitsubishi, 954-371-7895. So from these phone numbers and those records are where we're getting the information as to where the people work. So ladies and gentlemen, I encourage you to go through and look at those records. Look at who the subscriber is. Jamie King was paying for the phone of Anthony Williams and Jamell Demmons. Doesn't mean she was using it. In fact, she's listed under the billing information, and that's her number. So you have that, and that's the 772-713-9807. And you can tell the date the service began, November 30th, 2017. Ladies and gentlemen, it's important to look at these things and things that start before the murder. Because when people are creating email accounts, when they're setting up social media, when they're buying phones years before, they're not trying to hide anything at that point. So I submit to you that those are things that are reliable because there's no motive at that point to lie. So we have, again, like I said, she's under the billing for Miss King. So we have Cortland Henry. And so if you recall, Detective Moretti talked to you about Cortland Henry. Because it was a question of, it's so weird he doesn't have a phone. Well, you learned that the phone that he had was a pay-as-you-go phone. So it was a minute phone. And you also learned that every single phone call that came into that phone on October 26th of 2018 went straight to voicemail. What's a reasonable inference, ladies and gentlemen? The phone wasn't on. He didn't have minutes, or it was broken. That's what those records show. They don't show Mr. Henry making a ton of phone calls and passing the phone off to someone else. No, they show a phone that was not operating. So, looking at the CDRs, so this is from Mr. Demmons, the 9807 phone number. What I've done, 840-34 at the top, that's going to be this. But for the time in question, October 26, 2018, you subtract 4. That's the same whether you're looking at the CDRs, whether you're looking at the Facebook or Instagram records. So that way you can help and cross-reference to see what's going on with an individual phone and where that phone is when these messages are being sent and when the social media is being accessed. So if you recall, ladies and gentlemen, we learned that the 805-631, we learned that the 805-637-7249, if you see an incoming phone call, and then that immediately outgoing to that number, it says it goes to voicemail. So right there, you have at 5:03 a.m., Jamie King calling the phone of Jamell Demmons, her son, and being sent straight to voicemail. Then you have an incoming phone call from Frederick Givens, Frito Bang, that lasts 491 seconds. You then have another incoming call, only 11 seconds, and then Jamie King again sent to voicemail. So let's talk about the surveillance footage. And I know, I warned you ahead of time, there are some parts of this that are incredibly boring, utterly tedious, but they're important. And sometimes it's the smallest details that show that, look, this is what it says it is. So you have here 3:35 a.m., 36 seconds. And as you recall, this is the camera that sits on 595 on the entrance and exit to the express lanes. You learned from Detective Moretti that the express lanes toll camera all the way out past 136th Street. So ladies and gentlemen, from here, you know from the studio at 3:19 a.m., we're now 3:35, 16 minutes later. We have two cars, and you can go and pull this up, and if you need any assistance with doing that, we'll be happy to bring it back up in court and show it to you. You have two cars, and you can watch. So the top lanes are looking east towards Fort Lauderdale. So when you watch these videos, you'll see two cars that come here on the eastbound, and then they're going to pop up down here on the westbound camera, and they're heading west. And ladies and gentlemen, I submit to you that if you watch these two cars, one red and one gray, you will see them come up here and go to the left to get onto the ramp over to I-75 South. You can see here the lights going to the Sawgrass Expressway up to the Panther Arena. But if you watch those two cars at 3:35, that's what you will see. They go over to the left, head south towards Miramar Parkway. And so what you've learned, again, we have the camera icon, and then we have where the phone suggests the network it says it is. Blue dot right there at the bottom. Again, meters, not miles. We then have McDonald's, 3:47:56 and 3:46:57. So 1 second apart on those two cameras. And there, remember we saw the red car go first, then the gray Jeep on 595. You're looking here, red car, gray car. So, on surveillance footage, when a business, a private residence, puts up surveillance cameras, they're not there for the benefit of law enforcement. They're there for the benefit of that business. So they're not required to capture the street that goes by. They're not required by any law to maintain those videos for any longer than they feel is necessary. They're there to make sure that if someone's coming through and burglarizing their business, they capture that information. The fact that they also happen to catch the cars going by is dumb luck. But this is not just dumb luck, because this is one of the parts of the investigation that Detective Moretti talked to you about. That they went out and went to multiple businesses. And look, these aren't officers that have been there 2 weeks on the job. Detective Moretti talked about, yeah, I've done tons of investigations at Walmart. I know their video retention policies. This is their jurisdiction that they are intimately familiar with as to where these cameras are and what they show. If you have a camera that's pointing in the completely wrong direction, you don't need to waste time to go in and look at something that's not going to show you anything. Or if you know the data retention period has already passed, because most are 7 days or less, you don't need to go back and do that again. So if you look at, again, we have the McDonald's. This is where the network thinks the phone is at 3:47. Meters, not miles. But this is showing you that those records are accurate. They're not explicitly precise, but they are accurate. Going to 3:53 a.m. This is the Montessori Academy. So ladies and gentlemen, you can see there's the Montessori Academy, and there is traffic. There is a car that is consistent with that gray Jeep going by at 3:53, at 4:06, and again before 4:20. You can watch that and look at that. It's not like there's no cars, there's nothing out there. There is things that corroborate that cell phone evidence. We have Sunset Lakes. That shows, and again, 3:50 a.m. So ladies and gentlemen, you learned a lot about the geography of Miramar and Fort Lauderdale and the distances between them. You learned from 805 Northeast 4th Avenue in Fort Lauderdale, Florida, to Sunset Lakes, the 40th Street Visitors Entrance. You're looking about 31 miles. Detective Moretti talked to you about driving that route, and rather than spend 45 minutes doing that drive, he instead did the 16-minute version flying over it to be able to show you all of these locations in a much quicker, expedient process. So you know that the red Mitsubishi goes 30 miles in 30 minutes. That's an average speed of 60 miles an hour. And so you have in that the phone of Dontavius Withers. Mr. Withers has been identified as the person who was driving. And you have Travion Glass in that front passenger seat. Ladies and gentlemen, watch that video, please. You can see Mr. Glass moving his hands. You can see that he's awake at the time at this guard gate. Watch it. If you need help, again, we're happy to assist. So then we have 4:03 a.m. So at 4:03 a.m., ladies and gentlemen, we have a very specific location the network thinks the phone is. And this goes back to being in the big city, right? We're here in this courtroom. Right there we can see 3rd Avenue out the window. We can see the New River. Phone doesn't know if we're on the 4th floor, 5th floor, 6th floor. But we could be anywhere in this building, right? That's the beauty of Pembroke Road and US 27. Because what you've learned, ladies and gentlemen, is that on the west side of Highway US 27, there is a canal. You've learned that 208 Avenue is gated on the north and the south ends. That there is a Pembroke Pines fire training facility out there, so it's locked. You've learned that at the end of Pembroke Road, out here to the east on this map, there's another set of closed gates that prevents any further eastern traffic. You've learned that there's a waste management recycling facility out there. Again, another gate, an area you can't get into easily. So because of that limits the places the phone can be. It's not in a helicopter, it's in a car. And we'll get into that in just a little bit. So let's talk about the time in advance. For Mr. Dennett's phone, I want to make sure it's clear when you're going through outdoor stationary I've highlighted in green. So from 319 outdoor stationary, mobile, 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 till 403, outdoor stationary, then mobile again, all the way until 440. Why is that important? Well, let's look at the pattern of travel. Let's look at what the phone is showing where it thinks it is. Ladies and gentlemen, just think about cellular telephones. Think about how they can tell you're mobile. Most human beings can't run 60 miles per hour on their feet. So if you think about the speed at which a phone is traveling, that's going to tell the cell phone company whether it's mobile, inside a building, or outside. If someone is outside, not moving, Nothing's obstructing. There's no concrete, there's no rebar, there's no electrical wiring interfering with their phone getting a clear signal to a tower, to the satellite for GPS. That's going to tell them outdoor stationary. And ladies and gentlemen, this is common sense. These are things that you know on a daily basis that you have to deal with your own cell phones. You go into a really tall building, hard to get a signal. You have to go out to a window. And just because that is out there, ladies and gentlemen, doesn't mean that we're saying it's 100% accurate. We're saying that it is reliable on that it is also able to be corroborated by other evidence. What do I mean? 3:18 a.m., where it says the defendant is outdoor stationary, guess what the video at the studio shows? The defendant outside. When it says out here at 4:40 and 4:42, outdoor stationary, guess what the other evidence shows? The defendant outside sending a drop pin to his buddy from that phone. So let's talk about the pawn slip. All this goes to showing when you're not...
I'm sorry. It's a good time to do it.
Yes, sir.
I'm told someone needs a restroom break. We'll take a short recess. Do not discuss the case on the phone. Including publication on our own. Discuss the case in present, serving no research. Thank you. Just leave no space on your chair. It's the jury work. Step down, counsel remain along with the defendant. He needs a restroom break, so could you arrange that for Mr. Bevins, please? Yes, sir. Thank you. Recess. Gary, can you see, sir?
I don't know. They putting it together. Y'all.
Buying phones years before. They're not trying to hide anything at that point. So I submit to you that those are things that are reliable because there's no motive at that point to lie. So we have, again, like I said, she's under the billing for Miss King. So we have Cortland Henry. And so if you recall, Detective Moretti talked to you about Cortland Henry. Because it was a question of, it's so weird he doesn't have a phone. Well, you learned that the phone that he had was a pay-as-you-go phone. So it was a minute phone. And you also learned that every single phone call that came into that phone on October 26th of 2018 went straight to voicemail. What's a reasonable inference, ladies and gentlemen? The phone wasn't on. He didn't have minutes, or it was broken. That's what those records show. They don't show Mr. Henry making a ton of phone calls and passing the phone off to someone else. No, they show a phone that was not operating. So, looking at the CDRs, so this is from Mr. Demons, the 9807 phone number. What I've done, 840-34 at the top, that's going to be the time that reflects on the records as you can look at them. That's the UTC. So as you've learned, that the difference between UTC, or Greenwich Mean Time, in Florida, on October 26th of 2018 is 4 hours. So that is 4 hours ahead. So to get from UTC time to Florida, you subtract 4. Until November 4th, whether you're looking at the CDRs, whether you're looking at the Facebook or Instagram records, so that way you can help and cross-reference to see what's going on with an individual phone and where that phone is when these messages are being sent and when the social media is being accessed. So if you recall, ladies and gentlemen, we learned that the 805-637-7249, if you see an incoming phone call and then that immediately outgoing to that number, it says it goes to voicemail. So right there, you have at 5:03 a.m., Jamie King calling the phone of Jamell Demons, her son, and being sent straight to voicemail. Then you have an incoming phone call from Frederick Gibbons, Frito Bank, that lasts 491 seconds. You then have another incoming call, only 11 seconds, and then Jamie King again sent to voicemail. So let's talk about the surveillance footage. And I know, I warned you ahead of time, there are some parts of this that are incredibly boring, utterly tedious, but they're important. And sometimes it's the smallest details that show that, look, this is what it says it is. So you have here 3:35 a.m., 36 seconds. And as you recall, this is the camera that sits on 595 on the entrance and exit to the express lanes. You learned from Detective Moretti that the express lanes toll camera all the way out past 136th Street. So ladies and gentlemen, from here, you know from the studio at 3:19 a.m., we're now 3:35, 16 minutes later. We have two cars, and you can go and pull this up, and if you need any assistance with doing that, we'll be happy to bring it back up in court and show it to you. You have two cars, and you can watch, so if the top lanes are looking east towards Fort Lauderdale. So when you watch these videos, you'll see two cars that come here on the eastbound, and then they're going to pop up down here on the westbound camera, and they're heading west. And ladies and gentlemen, I submit to you that if you watch these two cars, one red, one red, you will see them come up here and go to the left to get onto the ramp over to I-75 South. You can see here the lights going to the Sawgrass Expressway up to the Panther Arena. But if you watch those two cars at 3:35, that's what.
All right, Philip, I'll start with you. What are your thoughts right now on the prosecution's closing argument, the start of it?
It's very compelling. I mean, when you lump together the ballistics, the digital, the GPS, the phone data, I'm telling you, it's almost irrefutable. In fact, they did not counter it in the defense case. So right now, I think the prosecution is scoring points, and I think Jamell Demons is in some pretty serious legal trouble.
All right, and Megan will give you an opportunity as well. What do you think?
I agree with Philip. The government's doing exactly what they need to do. They're taking the evidence that the jury has seen and tying it together in a really compelling way that's going to refute the lie, the alleged lie that came after the fact that this was a drive-by shooting.
Okay, and we're just at the start of this right now. Philip, I know we have to sign you off. I appreciate it.
We're ready, Judge.
All right, you bring it.
Jury entered.
Ladies and gentlemen, thank you. Please be seated. Let the record once again reflect the verdict of our jury. The defendant, Mr. Demons, his client, his counsel rather, and the assistant state attorney. Counsel, if you're ready to proceed with your closing, you may.
So continuing on the pawn slip. Why have a pawn slip, right? Seems kind of silly. But again, this goes back to showing that you're not planning a murder.
Excuse me, Gary?
Yes, sir.
Just keep moving, podium. This one here. Thank you. I'm sorry, go ahead.
When you are not planning a murder, you use your real phone number. And this isn't, oh, this was where I could be reached. He was pawning jewelry. You have this in evidence. And you heard from Inger Allen, who testified that that is the defendant's thumbprint. You have his signature, where he is stating that everything on that document, that the facts stated in it are true. There's a fact. His cell phone number is 772-713-9807. So I'm going to go to the Department of Highway Safety and Motor Vehicles records. You have his name, his driver's license number, his signature. The same driver's license number, signature, and name that you have on the pawn slip. Then you have the booking prints, where you heard from Deputy Maycock that yes, he took the prints of the defendant on February of 2019. And that is the same thumbprint that's on that booking print that's on that pawn slip. So let's talk a little bit about the cast analysis. That was the FBI, Special Agent Brendan Collins. He looked at not just one phone, but compared and contrasted two phones in each of these particular analysis slides that he compiled. And those are in evidence, and you feel free to look at those and refer to those. So we have here between 3:20 a.m. and 3:57 a.m. 772-713-9807, Mr. Demon's phone, and the 9081, Mr. Williams' phone, are all tracking together. If you recall, when there's circles, Special Agent Collins is indicating they are using the same cell tower. He's not plotting in terms of the distance on those. That's all he's indicating with that. So this is showing the pattern of travel, that at each of these points, they're using the same cell towers. So ladies and gentlemen, you've learned that the phones of Mr. Demons and Mr. Williams travel in from 3:20 a.m. in 40 minutes all the way out to US 27 in Pembroke Road. And so why is that important? You've learned from watching the videos of the geography how long it takes to get from the studio out to 184th and Miramar Parkway. That's about a couple blocks north of the Sunset Lakes 40th Street entrance. You've learned that. So now you know that how long it takes to go all the way up to Pines Boulevard, because as you've learned, Pembroke Road doesn't go through. You have to go all the way to Pines to get across. So then on the other side, you have Mr. Thomas in the gray Jeep, the deceased in the rear passenger seat, and Mr. Withers, the driver of the red Mitsubishi. And they're both on Sprint. If you recall, Mr. Demons and Mr. Williams, same phones, same phone plans. Mr. Thomas, Mr. Withers, both on Sprint. Because at this point, T-Mobile and Sprint were two different companies. They have since merged. Again, you're showing the same pattern of travel. From the studio, going north up to Sunrise, Sunrise down I-95, 595 across to I-75 south to Miramar Parkway. And they are showing consistently traveling together. Then we have Francois Track, his phone. Here's his alibi. He's home. This is the Margate, Toscana apartments that you heard about and learned about. He is nowhere near US 27. He's nowhere near the recording studio. He's at his home in Margate, his apartment, until noon the next day. Then for some reason, at noon, on October 26th of 2018, Jamison Francois' phone is out there in that same US 27 in Pembroke Road location. And so is that of Mr. Demons. Very odd location to go to. Nothing out there, except evidence of a murder. And ladies and gentlemen, you know the number of shell casings that were found at that scene. And you know that there's at least A through Q fired into the outside of that vehicle. Not including the ones inside the vehicle, in terms of the number of shots that are fired. But they're going back there. So going back to Mr. Demons' phone at 4:40 a.m. Remember the timing advance bands. So at this point, at 4:40 a.m., you also have seen the Memorial Miramar video, where at 4:35, and Memorial Hospital is right here, at 4:35, 5 minutes earlier, Cortland Henry drives the gray Jeep into the hospital with the 2 deceased victims. So you know where Anthony Williams is, you know where Christopher Thomas is, and you know where Cortland Henry is, because it's on video. So then you have the timing advance band. And again, this goes to, where is the phone? Because the phone, you've learned, connects and talks to the tower no matter what. But the phone doesn't make outgoing phone calls on its own. The phone doesn't send text messages on its own. That takes user input. So here's an example of the drop pin at 4:42 a.m. to Frederick Gibbons. This is from Special Agent Collins, showing where on this red band the phone would be based on the phone network records. Then we have the phone itself saying where it is. Pretty consistent. So let's talk about whose phone it is. And I know it was a lot of video of pictures to watch. I know that. I'm not going, and we all know that I can count to 500 and so. So I want to make sure that everyone understands why it's important as to who the phone shows. All of these photos, all of these FaceTimes show the defendant. There's not a single instance that's been put before you in that phone, which is in evidence, it states 64 of the extraction, and then the phone itself as well, that says, hey, this is so-and-so, I'm using Melly's phone. You don't have that, because it doesn't exist. Instead, you have this defendant using his phone. And he's the only person using this phone. And so, ladies and gentlemen, it's important to note that this isn't the polished, perfect shots. These are the outtakes. These are the ones that aren't suitable for public consumption, that aren't put out on Instagram, that aren't put out there to promote an album or anything like that. These are the raw images. That's why it's important to look at those. And ladies and gentlemen, just because there's a photo on this phone of something else, if you take a photo of your dog with your phone, it doesn't mean it's your dog's phone. You're taking pictures of what's important to you. I submit to you you can tell based on these photos and these videos what's important to this defendant. The videos. Just going to play one, but this is, like I said, a sample of the 1,000 some. This one is interesting because you see the reflection of the phone in the glasses.
You see, this is good. I clean this a little bit. I have a little too. You look at my mama. That my mama.
The videos also show, if you recall, the video of the Western Union transaction. 772-713-9807. October 2nd of 2018. This is the only individual that is using this phone. Talking about the jail call. You heard about 6 minutes of this call, and of which part there's 2 minutes where it's silent. What is that? We learned during the course of that call that the phone, 772-713-9807, didn't have money to pay for the minutes for the jail call. So ladies and gentlemen, I'm going to remind you what that jail call said.
Hello, this is a collect call from an inmate at Broward County Main Jail. This call is subject to recording and monitoring. To continue, press 1. To disconnect, press 2. Thank you for using Security. You may start the conversation now.
Hello?
Hey, Mom.
Hey, baby. Why you didn't just call my phone where I got my credit card linked to?
Huh?
You should have called my phone, baby, because I put money on my phone.
It's money on my phone.
No, you out of money. It said that this is not with this. I just put my credit card on your phone now.
Yeah, oh, yeah, you could have. Oh, yeah, my credit card is equipped.
Yeah, I don't know your credit card number because it asks for like your expiration date and your zip code. I don't know what your stuff is that's linked to that card. What is your 7-Eleven? Like 7-Eleven in your life. What you doing, baby?
Yeah, I'm driving. Just a credit card. I'm gonna give you my credit card number.
Well, I'm trying to get back your phone because he said I'll be answering the phone when I'm supposed to.
Yeah, you gonna be working and all that.
Yeah. Oh, he said he love you, keep your head up, and everything. And then, yeah, Easy. Where's been texting your phone? I ain't been reading your stuff, but you got like text messages from him. I didn't know if you want me to call him or anything on three-way or.
Yeah, but I'm having to call Justin home.
Who is that? Hold on. You got your number?
Yeah, it's on my phone. Justin home.
Oh, P. Diddy's son. Okay. Hey, I got the bridge. The bridge went up. Okay, yeah, we put in the GPS for 7-Eleven. Okay, yeah, uh-huh. So I go under contact, you go under Justin.
Yeah.
What's the number? It said I need facial recognition.
762556.
7. Oh my God, I'm trying to drive, I'm trying to do this. Hold on, 7625556.
Yeah.
Yeah, right, can you drive real quick? I just like, hold on, I'm about to have Mariah drive so I can do this for you. But I'm trying to do too many things at once.
So what did we learn in that phone call? I fast forwarded through the part where they're putting the credit card phone number in. They use GPS. They find it reliable to find a 7-Eleven. That's the defendant's phone. Why are you calling my phone? That Mariah is there with Jamie King. And that is the phone number that's being called. That's being identified as my phone by the defendant. So let's talk about some of the text messages. And ladies and gentlemen, you will have those to go through and look at them. You'll have the one, and I submit to you that crazy or crazy lady is Jamie King. Go through, read those messages. You can see it's a mother-son relationship. I love you, kid, son. All of those types of endearments showing you who's using the 9807 phone. We also have with Anthony Williams. He's listed as the contract as twin. Ladies and gentlemen, we've gone over the messages where you can see the animosity, that there is some tension between Mr. Williams and Mr. Demmons, where Mr. Williams is making it clear that, and I will fully agree, Mr. Demmons was a talented musical artist. Anthony Williams had not had that level of success. Christopher Thomas didn't have that level of success. They don't have that opportunity because the defendant killed him. But the defendant was making money. He was the one that was the revenue source, the meal ticket in that house. Look at the messages. Look at the tone of them. Look who's asking for money. Look at the way they communicate about things for the house, about food. And look at where Anthony Williams is saying, look, I'm the CEO. The others are artists. Anthony is saying, myself, Mr. Demmons, Mr. Thomas, we're the CEOs. But at that time, Mr. Demmons is the only one who's actually putting in the work, who's doing anything, who's making the money, who's recording the songs. You have the chat with Frederick Gibbons. And ladies and gentlemen, that is the one in which the defendant asked to be picked up from the side of Pembroke Road. That's that drop pin that we talked about in relation to the cast records. That phone is being used by the person who committed the murder. And ladies and gentlemen, the only evidence before you, the only evidence is that the only person that used that phone was the defendant, Jamell Demmons. So go through and look at some of the videos. You have the studio video. You have the brief clip of the documentary. Watch what the defendant's doing with his phone during that. Glued to that phone. Glued to it. So let's talk about the activity and the location data. What does this show? We have on October 25th of 2018, 8:14 p.m., a scent of a CL, or a current location, a drop pin. That one is sent to Anthony Williams. You can look at the messages and look at all of this and verify all of these things. Then the next one, going from the bottom up, we have 4:42:49 a.m. That's the first one on the side of 178, just south of Pembroke Road, mere blocks from the hospital. Then we go to the second one, 4:53:30. You can look and you can see, based on the numbers, how close those two drop pins are from one another. Negative 80.38, negative 80.38, 25.98, 25.98. And you can see the time difference between the two of those. And then, this part is key. The next Wi-Fi the defendant connects to is not at his house, not at the YNW Castle, but at Frito Bangs. Because, ladies and gentlemen, the defendant committed the murder, dropped off on the side of the road, and then needs to find a way to get home. They can't go home because the other people in the red Mitsubishi, they didn't know what happened. And they need time to get their story straight. And police don't know about Frito Bang's involvement. In fact, police don't find out about Frito Bang and the picking up of this until February and March of 2019, after the defendant's in custody. So what we had to look at now, Frito's house Wi-Fi, 8:47. And then look, it connects back again automatically at 12:27. That further verifies and corroborates the trip back to US 27 and Pembroke Road at noon that I submit to you was to pick up shell casings. Then we go back and we have the one that we did in open court, the one at 6:41 p.m. It is at that location at the video shoot. 10:27 at 3:02 a.m. That is the next time the defendant returns to that house. The YNW Castle, the 18521 Southwest 44th. Ladies and gentlemen, sometimes common sense is not so common. And these details are things that are not being contemplated after the murder. Because if the version that was brought in by Mr. Davis, the defense witness, is to be believed, that phone should have gone to the house. That phone should have connected to the YNW Castle Wi-Fi, not be sending drop pins all over the county and then connecting to somebody else's Wi-Fi before finally going back to that house. So remember, that phone showed mobile all the way till 4:03 a.m. That's when it went outdoor stationary. Ladies and gentlemen, I submit to you, that's when that drive-by was staged and the victims were killed sometime between the highway at Miramar Parkway and I-75 and getting out to US 27. Because you learned they were dead for some time. And look, there's no way to put an exact amount on there, but hearts were not beating when that drive-by was staged. So then if we go into the steps. If you recall, the drop pins, 442, 1,397 steps, 945 meters. And ladies and gentlemen, you can go back, and this is in evidence, you can look through and see when the defendant's at the studio, in the recording studio, you don't see this type of movement. If the defendant was home in bed, you wouldn't have any activity. As to if it's 70 steps, 80 steps, 50 steps, you would have 0 if the defendant was home in bed with his phone. As you recall, 4:03 a.m. is when the phone is saying outdoor stationary inside of Pembroke Road 27. So let's go to Felicia Holmes. Felicia Holmes, I think it is safe to say, hates me. And I'm okay with that. Because my job is to prosecute a crime and prove that it happened. Ms. Holmes didn't show up for a summons. There are consequences if you do not comply with court orders. You were served a jury summons to show up, just as she was served a subpoena to show up. I'm not going to apologize for doing my job. But what I am going to say is remember her testimony. And I have to say, the photos are courtesy of Law and Crime, so I appreciate their allowing me to use those. Ms. Holmes did everything she could to not perjure herself. Because she didn't want to say she lied to law enforcement. that? Get her in trouble. So it shows this whole, I don't remember. But even with all of that, she did remember one very important detail. Mr. Demmons on a FaceTime call with her daughter. So you know at that point, ladies and gentlemen, that Mr. Demmons...
Objection. There's no such testimony. I object to that.
Thank you. Ladies and gentlemen, you are to rely on your own recollection of the evidence. This is counsel's estimation of what she believes is an evidence. Proceed, counsel.
You heard from her mouth that she heard her daughter scream, and that then she spoke with the defendant on FaceTime.
Objection.
Thank you. Same ruling, ladies and gentlemen. You are to rely on your own recollection of the evidence. Proceed.
She was asked if it knew about a drive-by shooting, because the cover-up has already started. And remember, Cortland Henry is at the hospital. 4:35. Mr. Demmons is not. But they've already worked out this story to try and get away with murder. Whatever was said on that phone call was so troubling and so disturbing to Ms. Holmes that she and her daughter then drove immediately to Broward County. She remembers Frito Bang's house. She remembers lunch. But doesn't remember the contents of the call, doesn't now remember the phone number that was used or anything like that. Doesn't know her 17-year-old daughter's phone number at the time. Ladies and gentlemen, common sense. A mother is going to know her child's phone number. And don't forget, ladies and gentlemen, that little detail about the $5,000 that she got, that wasn't from the state. She says, oh no, that was for a vacation. Ladies and gentlemen, that was hush money. That's what that $5,000 was.
Objection. There's no evidence for that.
Ladies and gentlemen, you are to rely on your own recollection of the evidence. This is argument. Proceed.
So if you recall, Ms. Holmes identified that driver's license in the Snapchat video. That's her daughter, Mariah Hamilton. You can see, again, one of the photos that was previously shown. Ms. Hamilton and Mr. Demmons spoke on FaceTime all the time. And Mr. Demmons took screenshots all the time. Always making content, whether on purpose or not. Every single time that you can see this is an example of showing this was his pattern. And ladies and gentlemen, remember Ms. Johnson from T-Mobile. The call detail records are just that, calls, not data. A FaceTime, a video communication, is a data usage on a phone, not a cellular telephone call. So you're not going to see a cellular telephone call on the CDR showing Ms. Holmes and Ms. Hamilton's phone call from the side of the road. Travion Glass, the red Mitsubishi. What did we learn from Mr. Glass? We learned that the red Mitsubishi did not stop at the gate. And ladies and gentlemen, that's consistent with the physical evidence, with all of the cell phones, with everything else that cannot be changed by a person's failure to recall, that is in the records, that is on video. That's what you can show to corroborate, to show that he is being honest. Mr. Glass said Mr. Demmons was not in the car, that red Mitsubishi, at any point on October 26th of 2018. Same 4 people got in, same 4 people got out. He recalled the different clothing the defendant was wearing at Frito Bang's house. And he authenticated those photos that Danny Polo first introduced, that those were from that evening, where you see Anthony Williams sitting on a couch smiling, where you see Christopher Thomas animated standing up, where you see Jamell doing a handshake with the engineer. And look at those photos, ladies and gentlemen, because if you zoom in and you look up at the top of the one photo where the engineer is sitting down at the computer, and Mr. Demons is standing up, you can see the exact same screen grabs of the studio surveillance footage that you watched. You can see the red Mitsubishi and the gray Jeep parked just as they were. So Mr. Glass said that the red Mitsubishi did not stop. Just because you're in a courtroom doesn't mean common sense doesn't apply. If you fall asleep in a car and the lulling motion of the car driving puts you to sleep, that first red light, when you get off that interstate, wakes you up. These are things that you can rely on in your own personal experience to say, oh, yeah, that makes sense. That the red Mitsubishi didn't stop. That the 30 minutes and 30 miles are consistent with one another. That there was no stopping on the side of the road. And also, there's no reason. There is no reason that's been put before this jury whatsoever. Not in the phone records, not in the Snapchat, nothing that explains why 8 people that are going to the exact same location would stop on the side of the road. Just one person would switch a car. No reason whatsoever. And ladies and gentlemen, you can look at those videos and see the cars are tracking together. The phones are tracking together. All the way through until they get to 184th. So we have the memorial mirror mark that gives us that timestamp on Mr. Henry. And we also know that here Mr. Henry changed clothes. So we have in short sleeves at the studio, and now wearing long sleeves as he runs in to talk to Officer Amangor, who was the detail officer working at the hospital. So what you have learned from this, and you can watch it again, they first bring in the body of Anthony Williams, who's that front seat passenger. Then they, in the picture, so you can see from the Jeep at the hospital, they then recline that seat all the way forward to take out Mr. Thomas, and they bring Mr. Thomas into the hospital. I'm not going to play the video now, but so you know at this point that Cortland Henry has changed clothes. And that'll become important again in a moment. So George Mello. I don't think he has dropped off your certificates and firearms, but I am assured they are coming. You learned that he is part of the Broward Sheriff's Office Crime Lab, Firearms and Tool Marks Unit. That he is the manager of that unit. That he has worked in that particular area for a number of years, both here and in Dade County. And you learned more about firearms and how a casing is marked by a firearm, how a projectile is marked. And this is just some of the things that you learned. Shapes of firing pins, breech face marks, extractor marks, ejector marks, lands and grooves, rifling, the class characteristics, which means every specific Glock 19 has these same class characteristics. The rifling, the lands and grooves, right? Those are going to be the same for each Glock 19. But then you learn the individual characteristics are the things that make each firearm unique. So what did you learn specifically on this casings and projectiles? So starting with the projectile, this was recovered from Anthony Williams. This was from his shoulder. We have the ones from Christopher Thomas, and this is just a sample of the 7 that were recovered. So what do you learn about all of these projectiles? You learn about the projectiles from the Jeep. And again, this is just a sample, not all of them. So you learn that numbers 13, 14, and 15, right? So those are going to be the ones from the Jeep. And the easiest way to reference all of these, ladies and gentlemen, is the G number. The group number, which is the one that's assigned by Miramar, and that's on the packaging for each of those particular items of evidence. So you learn that 13, 14, and 15, which came out of that Jeep, were all fired. 13 and 15 are definitely the same weapon. And 14 is very likely to be the same, but it has too much damage to make a full conclusion on that. So then on the ones from Mr. Thomas and Mr. Williams. That's the G44, 57 through 63. Again, some of them have both class and individual characteristics, which they could have been fired from the same weapon, and the rest have just class characteristics. And so then we have the cartridge casing. So this casing is at the passenger, rear, driver's side, floorboard. The exact seat Mr. Demons was sitting in a plastic bag. This cartridge casing is found October 26th of 2018. Then we go to November 21st of 2018, where you heard about the testimony they had to use the canine to find these particular artifacts. All these 8 casings are consistent and fired from the same weapon as the one inside the car. From this, ladies and gentlemen, and we went through the cantilevers, the lands, the grooves, the rifling on all of those. So we go through every single one, and that's G196 through 203. Right? They all match. And so you learn from George Bello that he doesn't have a weapon for comparison. And he gives a list, 30 or so weapons that could have caused this particular casing and projectile. Right? So you learn that without the actual firearm and the exact same ammunition, you can't do a range of fire or distance determination, because there are things in each firearm that would affect that. You want to, in any scientific experiment, make as few variables as possible. If you don't have the gun, can't do it. So then you also learn that if you don't have the gun, you cannot match the casings to the projectiles. You can match projectile to projectile and casing to casing, but you can't match one to the other, because there's different marks from different parts of the gun. Other important thing, George Bello specifically excluded Glock firearms because they have a different, very distinct type of rifling. So all of those Glock-related firearm things at Jameson Francois, no relation whatsoever to this case. I can tell you that was not the murder weapon. Can't tell you that what specific gun was the murder weapon, because it's never been found. There's never been another match to that to this day. So let's go to GSR. Tara Helsell came in and testified from RJ Lee. You learned GSR, primer, that's what she's testing for and looking at under the scanning electron microscope. Antimony, barium, and lead. That those 3, when all 3 are together, are considered GSR. That is a gunshot residue particle, all 3 of them. You learned that Mr. Henry has one 3-component GSR particle on his left hand. And then there are 2 component particles, so either lead and antimony, lead and barium, or barium and antimony, right? One on his left hand and one on his right hand. So you've learned that some of those maybe show up, the 2 component particles, in other circumstances. But generally you see a third element. I believe she referenced brake pads, and you could also see steel. You don't have that here, right? So you have a 3-component GSR and a 2-component GSR, 2 of those. So the G in 2023, you then have more than 9 2-component GSR particles found 5 years later. They're still there. And that you heard from Chris Williams, who obtained those during his shooting reconstruction and sent them in for testing. So what does that tell you about Cortland Henry? Ms. Helsel was very clear. She goes, I cannot say that GSR being there or GSR not being there means that someone fired a gun. She goes, there's 3 options. 1, they fired a gun. 2, they were in close proximity to someone that fired a gun. Or 3, they touched a surface upon which GSR was and it transferred to their skin. So ladies and gentlemen, with regards to the GSR, you've also learned that it falls off very quickly. So you have a Jeep covered in 2 component particles, and you have Mr. Henry having 1 after changing clothes. What you don't have is an answer as to Mr. Dennis, because he was never tested. Because he didn't speak to law enforcement that day, he didn't go to the hospital, he was never tested for GSR. Did nothing on that. So you can't draw a conclusion one way or the other as to GSR because there is no answer to that. So again, George Bello says all 8 casings are all from the same firearm. You can't have a drive-by and have a casing right up inside the car. Doesn't work that way. So then we get to Mr. Henry's statement, part of the cover-up. So you hear, I was getting sleepy, I was almost home. Out of nowhere, I heard gunshots. I ducked down, almost crashed the car. And these are from that sheet that you had. And if you want to listen to that statement again, those will be made available to you as well as the disc, but you would have to come out into the courtroom to look at those. So he's talking about ducking, hitting the median. He's embellishing, trying to sell this story. Because there's no evidence that shows any sort of tire damage, any sort of rim damage whatsoever. But no description, no idea what type of car, nothing on that. Because there wasn't one. But he is trying to build a cover story to take this defendant and separate him from the shooting. So as you learned, how Miramar Parkway is laid out. And you learned that the Miramar Police Department shut down Miramar Parkway and walked more than 2 miles. They walked from I-75 all the way to 184. And so when you look at Miramar Parkway and the geography of it compared to Mr. Henry's statement, it's interesting to note that the hospital is right there. If it had happened as he stated, we wouldn't have differing time frames on the postmortem wounds and the fatal wounds. That's a mile. From I-75 to 172nd, 1 mile. From 172nd to Pembroke Road, 1 mile. If that's where this happened, you would have evidence of it. And there is none. There's no casings, there's no glass, there's no projectiles. So from this, and all of the cell phone records show consistent path of travel all the way across Miramar Parkway to 184th. That is when everything splits. And if you recall, Detective Hector Bertrand testified when these maps were placed into evidence. So let's go to the DNA. On October 26th of 2018, Chris Carter swabbed the rear driver's side door handle interior. It wasn't tested until later because, ladies and gentlemen, as you can tell, investigations are fluid. They evolve. And let's not also forget we had 15 months of a global pandemic where nobody came into this building. So this isn't tested until later on. It doesn't change what's on the swab. As you've learned from both Kurt Rhodes, the DNA expert, if you have DNA on there and it's in an optimal environment, like a cotton swab, it's going to be there pretty much indefinitely. On this swab, when it is tested, from this door handle with the blood on it, here's what you have. Very strong support for Christopher Thomas. Limited support that Anthony Williams is also included. And very strong support that Jamell Demon's DNA is on that door handle. So ladies and gentlemen, when an item is tested, it doesn't change the results. There are many factors that go into when an item is tested. Witnesses aren't being cooperative. You have to come up with a different way to prove it. This is the other way to prove it, ladies and gentlemen. That his DNA was on that door handle. Let's go to the trace evidence. This is a very unique piece of evidence that you don't see very often in any case. And what does the glass on US 27 and Pembroke Road tell us? Let's think about this. The glass is on the north side of the road. Why is that important? So if you have Melly's murder mobile on the south side of the road, stage the drive-by, you now have a ton of shattered glass. Some in the vehicle, some hanging on. You have to leave that area. How do you go from facing eastbound on the south part of the road to going back to US 27, because that's the only way out, as you've learned, pop a U-turn. What happens when you pop a U-turn? All the glass that was in that vehicle is then thrown out to the north side of the road as they make that U-turn. So ladies and gentlemen, that's why this glass was collected, and that's what it shows. It shows the pattern of travel and the fact that this did happen in Miramar on the south side of Pembroke Road. So you have the different populations of glass, and you heard from James Morano that the two different types that he went through and he compared them, and that they are consistent, both the standards as well as the ones on the side of the road. It's another thing and another level of showing you that this Jeep was out there, that this was a cover-up, that this was not a drive-by. So let's go to the gangs. And ladies and gentlemen, I'm limited on time in terms of what I can talk about. So in some areas I'm going to be brief. This is one of those. Ladies and gentlemen, the evidence clearly shows the defendant is a G-Shine blood gang member. And so for the purposes of the jury instructions that His Honor just read to you, you have to determine if at the time of this offense, if the murder of his two friends benefited the defendant. And in benefiting the defendant and promoting or benefiting his position in the gang, it then helped the gang itself. You learned many, many things about G-Shine, the organization. And I think the most important thing to look at is to compare and contrast the public-facing, the YouTube videos, the gang signs, the music videos, the motto for the album, right? Those could be an actor. That could be a show put on for the public. But look at the private side, the not for public consumption. Look at those messages. And look at that, there is a benefit to both sides. The gang gets notoriety, gets money. The defendant, he gets access to different venues, as you heard. He gets protection. He gets a sense of whatever we want to call comes along with being a gang member. And so, ladies and gentlemen, you heard lots of testimony from Detective Danny Polo as to what the primary activities of G-Shine, of GKB, Gangster Killer Bloods, are. You learned that they're the enforcers. You learned that they are violent. You have that information before you in those text messages. The nighttime drive. This shows the conditions under which this murder took place. This is not an area you find by accident or misfortune. This is a planned drive out to the edge of the Everglades where there's not going to be any witnesses. This shows pre-planning and premeditation. This is a consistent, quick, no stops, no detours ride out here. And so some of the things that you can look for premeditation, the nature of the weapon used. So having the firearm already. And ladies and gentlemen, how do you know that they had the firearm already and the defendant had the firearm already? Because he asked for it the day before. Remember, on October 25th, Jamell Demons, 9807, sent a text message to Anthony Williams asking, where's the fire at? FYE. And Mr. Williams says, it's in here with us. And if you look at the context of the conversations, that shows they were driving down from a location in Stewart, and they were driving to pick the defendant up at the airport. Mr. Williams brought his own murder weapon to the defendant. Look at the rest of the conversations. There's multiple discussions about this firearm. Where's the firearm? From Mr. Williams to Mr. Demons earlier on. It's in my closet, third shoebox. This is discussed. That is not a lighter. That is not a really great song. That's a firearm, ladies and gentlemen. There is discussion about firearms. The presence or absence of adequate provocation. When you look at that and you're looking at this case, they were friends, right? They were buddies since they grew up. But look at the stress being placed on this defendant as the only one bringing the money in, as the only person who's paying the bills. Look at the tension on there, right? Look at the issues and concerns with Mr. Williams, Anthony Williams, and the defendant's mother, that they're fighting an argument. The messages on there to that effect. So look at, for premeditation, you can also look at the manner in which the homicide was committed. Anthony Williams was shot in the back of the head. That was planned for when he was sleeping so that he could not fight back. That was a premeditated, planned killing of Anthony Williams, where there would be an alibi already discussed. So then, Christopher Thomas. Premeditation, as the judge instructed you, does not require days, weeks, months of planning. Premeditation can be formed quickly. Example we used in jury selection. Going to your mom's house on Mother's Day. You forget to bring flowers. You reach down, pull some flowers out of her yard and give her to those. That is premeditation. That is thinking about something, then doing it. Ladies and gentlemen, I submit to you the murder of Christopher Thomas was premeditated in that as well. Chris Thomas, as you saw with Sergeant Williams and Mr. Howard demonstrating, oh my goodness, what's going on? Mr. Demons then made the decision at that point he couldn't have a witness. So look at that. Those are all things in which you can get premeditation, how it was committed, the wounds that were inflicted, the back of the head. Going to Facebook. Showing again that the different information that you have before you belongs to this defendant. 772-713-9807. And that Melly, Montana, at iCloud.com is the email. Remember the Snapchat? Melly.Montana. These are names that the defendant uses over and over again to talk about and communicate and identify himself. And look, that phone says verified as belonging to Jamell Demons. Also remember Facebook. We have October 26th of 2018. Sun's going down. And the defendant's phone also shows him at this location in Cocoa. And he is dancing and singing and performing, wearing the same jacket, an identical jacket to what Chris Thomas was wearing the night before, and showing Mr. Henry wearing the denim jacket, like Mr. Williams was wearing the night before. And so the question was posed about a contractual agreement and losing money to be there. Well, ladies and gentlemen, look at the text messages between Mr. Demons and his mother, because he wasn't worried a couple of months before about missing a show because he was getting his hair braided and losing $1,000. But then this night, when his friends were killed, he's dancing and partying around and is worried about a contractual agreement. Just look at those types of information and those types of behavior and how someone is acting. Snapchat. If you recall, this is the argument between Mariah Hamilton and Jamell Demons, Melly, Montana. Bort coming everywhere with me, because if them crackers come grab him, it's my fault, you forgot. I keep Portland with, because at the end of the day, he did one of the realest shit in my life. Yeah, he covered up a murder. Did a very terrible job of it, but that's what he did. That's what this is referring to. This is less than 2 weeks after this homicide occurs, and that's what they're talking about. Ladies and gentlemen, you have a confession in this case. The defendant, and now look at the time. Remember we talked about the UTC? So subtract 4. So UTC 2,000 hours. You subtract 4, 1,600 hours. You do the conversion. So 4 p.m. 4 p.m. I did that with the smiley face. And that's what I said in opening. Context is key. The whole floor is coding. Awesome if you work at Google. Terrible at Broward General Hospital. context is key. So you've learned PZ Gambino, as you heard from Detective Moretti, is potentially facing federal firearms charges, the gun dealer, is told by the defendant, I did that. Shh. And look at the messages between Mr. Demmons and Mr. Gambino. PZ Gambino is a blood gang member. He uses all those same information, slang words, changing of the letters that you learned about from Detective Polo. October 26th, he asks to reach out to see how the defendant's doing, and the defendant says, I did that. And to make a spelling that, other times he uses DAT. And gentlemen, you saw the song where he has a song that he's released called THAT in his phone. So again, Instagram and how these all fit together. 6:58 a.m. Jamie King, RN, the defendant's mother. Are you here? I'm in Miami. I'm by the stadium. I'm a mess. I'm so worried. I'm here. Well, remember those CDRs where you get sent your voicemail? Ladies and gentlemen, this shows that she's trying to contact her son. He is ignoring her, and so she's reaching out to her son, who responds back with, I love you, Mom. I'm good, Mom. Because he had the phone at that point. So the judge read you the law. Anthony Williams is dead, and it was premeditated. Ladies and gentlemen, I submit to you the evidence very clearly shows the defendant was caused by Jamell Demmons. Same as to Christopher Thomas. Talks about premeditation. Principles. So if, ladies and gentlemen, if you believe that Cortland Henry, and Cortland Henry is charged, but that's for another jury on another day. If Cortland Henry assisted and helped and shot these two individuals to help out Mr. Demmons, Mr. Demmons is just as guilty. Because a principal is someone who decides to help before the murder is completed. And you have that with Mr. Henry, and making that drive and going out to the edge of the Everglades. You have that. He is a principal to first-degree murder. Mr. Demmons is just as guilty, and so is Mr. Henry. So, in my few remaining moments, I want to briefly touch on the unlucky 13. Because I'll give Mr. Adelstein, Mr. Henry. He's charged, right? So from all those unlucky 13 people that are listed as suspects, they have one thing in common, and only one thing in common. They made a single online threat. In poor taste? Yes. Any other evidence that ties them to this case? None. No location data. No communication from anyone in that Jeep to say where they were. No DNA of any of those people on that Jeep. No ballistics evidence at their feet where they were sitting in that Jeep. No private confession. Because remember, all of these online threats, they're out there for the public because they're trying to get attention and trying to get some sort of benefit for that for themselves. Distasteful? Yes. A crime? No. There's no drop pins for an emergency pickup from any of those individuals. There's no phone for any of them at any of the scenes in this case. So, motive. We talked long and hard how we don't have to prove motive. Motive, it's intent. Intent is an action of the mind. So I'll give you motives. Anger. Greed. Resentment. Advancement in the gang. You heard $16 million was coming into Jameson Francois. and that you saw $15,000, $10,000 payments going to Mr. Demings. Simple math. Splitting something 4 ways or 2 ways with Mr. Henry, who wasn't smart enough to even properly give a statement to keep Mr. Demings away from the car. So we have all these pieces of the puzzle that we have just talked about. And each and every one shows how this case has been brought together. Shows the physical evidence. And so, ladies and gentlemen, there's no murder weapon, right? The question that you have to answer, and that you can now answer based on all of this evidence, is that Jamell Demings was sitting in the back seat of that Jeep. And he was the one that fired the fatal shots that killed Christopher Thomas and Anthony Williams. And you know that because even if you choose to disbelieve one part of the evidence, 2 parts of the evidence, you can see what the overall picture is. The overall picture puts Mr. Demings in the back seat of that Jeep. It puts him holding a gun. You don't need a murder weapon to know that he committed these 2 crimes. Ladies and gentlemen, I would ask that you serve justice, that you deliberate, and that you return a verdict of guilty as charged as to murder in the 1st degree. Thank you.
Can I see Counsel Slade represent?
Wait. That's what we've been waiting for. I don't know, y'all. I mean, I do know. I do. Guilty. Like she said, like I said,
deliberations at this time.
What?
The same admonition I gave you before, and every time the rule remains in full force and effect. You are not to discuss the case. Don't form any opinion about the case. Don't allow anyone to discuss the case in your presence. And certainly no research. Just leave your notepads on your chair and all those jury instructions. And we'll see you back in around 15 minutes of time.
man, I started shooting.
So I'm going to slide over the floor.
All right, so we'll see everybody back at, let's say, no later than 1:30, all right? Thank you. Nice one.
And evidence is, as she just showed again, is that back seat where there was no blood. The absence of blood means that there was somebody sitting there. And who got in the car in that seat? You make it make sense. Like, you make it make sense. I'm just saying. There was no blood in the back seat.
Any thought about the, what I was asking about?
Oh, I haven't even discussed it.
Okay, so.
I'll have an answer right after, before they come in, of course.
Anything else to discuss this time?
No, sir.
All right, see everybody back at 1:30, right? Yes, sir. Prayer 1:30. Thank you. Have a nice lunch.
Fall asleep in a car, and the lulling motion of the car driving puts you to sleep. That first red light, when you get off that interstate, wakes you up. These are things that you can rely on in your own personal experience to say, oh, yeah, that makes sense. That the red Mitsubishi didn't stop. That the 30 minutes and 30 miles are consistent with one another. That there was no stopping on the side of the road. And also, there's no reason. There is no reason that's been put before this jury whatsoever. Not in the phone records, not in the Snapchat, nothing that explains why 8 people that are going to the exact same location would stop on the side of the road. Just one person would switch a car. No reason whatsoever. And ladies and gentlemen, you can look at those videos and see the cars are tracking together. The phones are tracking together. All the way through until they get to 184th. So we have the memorial mirror mark that gives us that timestamp on Mr. Henry. And we also know that here Mr. Henry changed clothes. So we have in short sleeves at the studio, and now wearing long sleeves as he runs in to talk to Officer Amangor, who was the detail officer working at the hospital. So what you have learned from this, and you can watch it again, they first bring in the body of Anthony Williams, who's that front seat passenger. Then they, in the picture, so you can see from the Jeep at the hospital, they then recline that seat all the way forward to take out Mr. Thomas, and they bring Mr. Thomas into the hospital. I'm not going to play the video now, but so you know at this point that Cortland Henry has changed clothes. And that'll become important again in a moment. So George Bello. I don't think he has dropped off your certificates and firearms, but I am assured they are coming. You learned that he is part of the Broward Sheriff's Office Crime Lab, Firearms and Tool Marks unit. That he is the manager of that unit. That he has worked in that particular area for a number of years, both here and in Dade County. And you learned more about firearms and how a casing is marked by a firearm, how a projectile is marked. And this is just some of the things that you've learned. Shapes of firing pins, breech face marks, extractor marks, ejector marks, lands and grooves, rifling, the class characteristics, which means every specific Glock 19 has these same class characteristics. The rifling, the lands and grooves, right? Those are going to be the same for each Glock 19. But then you learn the individual characteristics are the things that make each firearm unique. So what did you learn specifically on this casings and projectiles? So starting with the projectile, this was recovered from Anthony Williams. This was from his shoulder. We have the ones from Christopher Thomas, and this is just a sample of the 7 that were recovered. So what do you learn about all of these projectiles? You learn about the projectiles from the Jeep. And again, this is just a sample, not all of them. So you learn that number 13.
All right, we're going to jump out of this for a quick commercial break, but I'm also learning court is now on their lunch break, which means our lunch Q&A will start as well. When we come back, Anjanette Levy will take over for the question and answer session with our law and crime legal guests. So get your questions ready for social media. We'll be right back.
Thanks for joining us here on Law and Crime. I'm Anjanette Levy, and we will be taking your questions during the lunch hour in the YNW Melly double murder trial for the next hour. So keep those coming to us on YouTube, Twitter, Facebook, TikTok, Instagram, and Threads, and we'll get to as many of them as we can. We are there, folks. The state has ended its closing argument, the first portion of its closing argument in the YNW Melly double murder trial. So the defense will begin its closing after the lunch break. YNW Melly, of course, legally known by his name Jamell Demons, his birth name, is facing 2 counts of first-degree murder for the murders of his 2 friends, Chris Thomas Jr. and Anthony Williams, back on October 26th of 2018. If he is convicted of first-degree murder, he faces a possible punishment of death under a lower threshold signed into law earlier this year by Florida Governor Ron DeSantis. His co-defendant, Cortland Henry, will go to trial later this year in October. So as I mentioned, we will be taking your questions for the next hour until the lunch hour concludes. So keep them coming to us. With me to talk about this case and to answer your questions is Terry Austin. She is down at the Broward County Courthouse in Florida. Also with me is Brian Buckmeyer, an attorney and host here at Law and Crime, and Offie Patterson. She is an attorney as well out in California. But Terry, I want to start with you. What was it like during closing arguments in that courtroom this morning?
Well, Anjanette, first of all, that courtroom was packed. It was hard to get a seat. I think both sides wanted to make sure they were there for those closing arguments. And this morning, we heard from Judge Murphy. He gave all of the jury instructions to the jury. Most of them were standard. He defined for that jury what is premeditated first-degree murder, and he defined also manslaughter, which is the lesser included charge, so they could understand the difference between those two. And I will note that we were wondering whether or not he was going to do that felony murder charge, and he did not give the felony murder charge. So it's just the first-degree murder, premeditated, and also the manslaughter. Then after that, it was a very short, not even a break, basically a minute. And the judge said, okay, are you ready? And Ms. Bradley got up to do her closing argument. I will say, I do think, Anjanette, it was succinct, it was organized. She went through all of the evidence, and she stated that the motive, which she said she doesn't have to prove, and she does not, she stated it was greed, and that most of the motive had to do with money and resentment, that she believes that Melly was feeling as though he was carrying the weight of that YNW Melly, the whole collaborative, and he was doing all of the work. And this is the motive she's stating for the shooting. So very interesting. She definitely went through all of the evidence, the gun, the DNA, the investigation, the drive, and she did it fairly well. And I thought that it was not too long. And you could hear a pin drop in that courtroom, both during the jury instructions and absolutely during her closing argument. And as you said, Jeanette, we will hear the closing argument from the defense team when we return.
And we want to take a look, Terry, very briefly at a clip from the closing arguments, and then we'll talk about it on the other side.
The red Mitsubishi. What did we learn from Mr. Glass? We learned that the red Mitsubishi did not stop at the gate. And ladies and gentlemen, that's consistent with the physical evidence, with all of the cell phones, with everything else that cannot be changed by a person's failure to recall, that is in the records, that is on video. That's what you can show to corroborate, show that he is being honest. Mr. Glass said Mr. Demons was not in the car, that red Mitsubishi, at any point on October 26th of 2018. Same 4 people got in, same 4 people got out.
So there was Christine Bradley in closing, just a small portion of it. She's using the puzzle piece analogy, that a lot of these prosecutors use in a circumstantial case, where they say, all of these puzzle pieces are going to come together and it's going to paint a picture for you. Terry, I want to ask you about another thing just really briefly. There was an instruction that Judge Murphy read to the jury where I guess the jurors are going to be able to consider manslaughter as a lesser included offense in this case, which was that surprising to you?
It wasn't surprising because there was an argument before about including that manslaughter charge, and the prosecution actually asked for it. And to me, it signals they want to make sure they cover all their bases. The defense did not object to the manslaughter, so they both on each side think that there's a possibility, I believe, that they could have that lesser included. I think at the end of the day, it depends on how you think the evidence went in. If you want that jury to have something else to look at, if they don't come back with that first degree, I think that helps the prosecution. So it's in there, and, it's there for them to consider. And the judge gave the definition and the difference between that first degree premeditated murder and the manslaughter, where you're not intending absolutely that they're going to, end up being premeditated. So that's what he ended up doing.
Brian, I wonder what you think of that, because it seems like a big leap from first degree murder, death penalty, possible punishment, to a lesser included of manslaughter.
Yeah, it doesn't make a lot of sense when you're going after that top charge and you're looking for the death penalty, but from the broader concept of we want to make sure we get him on at least something, I think it's more indicative of showing that the prosecution says, hey, there's a chance we can lose if we go for the ultimate punishment, so let's make sure that we have other options for the jury. She spent a very good amount of time, and I think she did a very good job, Prosecutor Bradley, in describing what premeditated was. The analogy of you forget your Mother's Day, and you go and you pull roses or flowers out just as you're approaching the home. That made sense, but I think for a case like this, and maybe why the defense didn't object, either you believe he did it or you don't. I don't think it's going to be a lesser included type of case.
Afi, what are your thoughts on this?
So I've been watching the prosecutor this morning, and I think she's been doing a solid job. I think that she is finally putting all the crumbs together that she's been piecemealing us. And I think she's definitely delivered a hot pie of conspiracy. I think that there's been just really good evidence that's been presented, which is the phone evidence. And for me, what was interesting was she pointed out the fact that there was definitely somebody in the car when Juvie and Zach were murdered. Who is that person? I think she did a great job presenting the evidence that there was nobody likely on that highway that night that could have gotten in the car. And I just think that, with respect to first degree murder or manslaughter, I think Brian said it, you either believe that he did it or he didn't. I think that the manslaughter was put in there. It's kind of like you can call it a catch-all if you want, or a backup if you want.
Yeah, it makes me wonder if maybe they think, okay, they're drunk and high and they're partying at the recording studio. He and Cortland fall asleep, and maybe something happened in the car and he didn't intend to do this, and it was an unintentional thing, but still did it. I wonder if they think the jury can reach that type of conclusion with the evidence that came in. Terry, let's get to the questions now. And Terry, this one's for you. So tell us a little bit about the schedule. It comes from Scully Wolf from YouTube. Is this the last day?
Well, this is the last day as far as anything going to that jury. They're going to hear the rest of the closing from the defense, and then they'll hear the rebuttal for the prosecution. The defense will get 3 hours, and then we'll hear from Christine Bradley, who does the rebuttal, and that will be 1 hour. And after that, we've already had the charges, so there's nothing left for this jury to hear. The judge will then hand the case over to the jury for them to begin deliberating. That will probably occur in the morning. It could occur this evening, but they will get the case and then they will begin their deliberations. My understanding is that today or Friday, once they start deliberating, they will end at 5:15. So if they end at 5:15 tomorrow's Friday, then they will, and they don't, let's say they don't have a verdict at that point, then they will stay over because they are being sequestered this weekend at the hotel. And we have been informed that they will come back. Let's say they don't have a verdict Friday evening at 5:15. They will come back on Saturday and they will deliberate here in the courtroom. They're only allowed to deliberate in the courtroom. And they could have questions. If they have questions, they ring the bell once. If they have a verdict, they ring the bell twice. And so we could very well be here over the weekend as well.
Could be a long weekend for that jury. You know, only they know where they will go with this. Brian, our next question is for you from Daddy Bars from YouTube. In this case, who would benefit more from a hung jury, the defense or the prosecution?
So let me put it the other way around. I think the prosecution will benefit in this, and this is why. If there is a hung jury, I think it's 100% chance the prosecution is going to want to retry Melly. And oftentimes, most people will tell you that the second trial, oftentimes a prosecutor has a greater advantage because a lot of the defense arguments that are made in the first trial, they're prepared for it. The defense's greatest strength in any case is the element of surprise. The prosecution has their case, they don't see the holes in it the way the defense does, and so the defense pokes those holes. But they go to a second case, the defense can't poke the same holes. They got to find new ones because the prosecution has then strengthened their case. So if it is a hung jury, I think it benefits the prosecution because of what will ultimately happen in that second trial.
Mm-hmm. Yeah, they basically get a do-over. You know, they get to see how it comes in, how the evidence is attacked, what the weaknesses and the strengths were of the presentation. So you just don't know when it comes to these things. All right, our next question is from Miss Duchess Florida, FLA, and it's from Twitter, Offie. The judge said the jury could charge him with manslaughter instead of first degree, in which he was charged. Is that normal to give the jury the option to choose a lesser charge?
Yeah, it absolutely is normal. It's called a lesser included offense. So you always want to charge the defendant with the highest charge that you think you can get a conviction for. But there is also, I hate to call it a backup, so to speak, and you can get those lesser included offenses in there, and that's what manslaughter is. Something that I found so interesting and important during the jury instructions as well is the judge said you don't have to render a verdict of not guilty just because there's reasonable doubt there. But if you have an overriding, abiding conviction of guilt, you don't have to render a verdict of not guilty. So I think that's also super important with respect to first degree murder versus manslaughter. I think it's going to be a lot easier to get that manslaughter conviction because of that jury instruction and just because of the lower threshold that comes with a manslaughter charge.
It's common, you know, for these prosecutors to request a lesser included offense. And sometimes the defense does it too. You know, not always, but it does happen. So it's just all depends on how they believe the jury could view the evidence once it comes in. All right, guys, we're going to take a quick break. Keep the questions coming to us on Twitter, Facebook, YouTube, Instagram, Threads, and TikTok. I think I got them all there. I might have repeated one. We'll be right back. Stay with us. We'll take more of your questions. I'm Anjanette Levy, and you are watching Law and Crime. Jeanette Levy, and thanks for being with us here on Law and Crime. We are taking your questions in the YNW Melly double murder trial, so keep them coming to us on YouTube, Twitter, Facebook, Instagram, Threads, and TikTok, and we will get to as many of them as we can throughout this lunch hour. The state finished its closing argument. The defense will be up after lunch, and then after the defense, there will be a rebuttal argument we expect from the state. So let's get to our next question. Latasha Gaffney from YouTube. The prosecutor said Melly didn't want to leave any witness behind, so why didn't he kill Cortland Henry? Do you think the jury is going to ask the same question? Do you think they caught that part? So I will send that one over to you, Terry.
So I think what the prosecution is trying to say as far as that is concerned is Melly wanted the other two, Juvie and Sack Chaser, gone because he didn't want to split up the money with them, but he felt as though Henry had his back. That was one of the messages she read to the jury during her closing argument. So I'm assuming that her theory here is he left Henry alive because he was more of an asset than the others. Now, if you believe her motive for these is, the greed, the resentment, then she's saying that he did not have, Melly, the defendant, did not have any greed or resentment or any of those things as far as Henry was concerned. So that's why he allowed him to live, according to the prosecution.
Samantha GM from YouTube, Brian, if the state is sure with unreasonable doubt that Jamell did it, then why are they prosecuting Bortland for the same thing?
That is a great question, but I think the difference between the charges are that they believe, and it got a little weird during the closing argument as well when she was talking about principle and who may have actually pulled the trigger. They seem to backtrack from what I thought they were originally saying, that being that Bortland was merely an accomplice or conspired to or aided and abetted in one way, shape, or form, but YNW Melly is the shooter. They spent a lot of time saying that the shots had to have come from the back seat behind the driver, not from the driver's side. So when they kind of interjected that, well, you could kind of believe that both of them did the shooting, but they would still both be guilty, it seemed like she was playing her hand to say, I don't have a very strong argument for this, but here's an avenue where you can think of it either two different ways and still find that I'm correct. I think it showed that her case was a little bit weaker, but giving an alternative to still try to come out on top. If the defense can pounce upon that, I think they have a good opportunity and a good argument to point the finger at Bortland.
Afi, this one's from TikTok, and it's for you. Couldn't the phone have been given back to Melly when Bortland met back with them at Fredo Bang's house? And this is from Che Joseph 23.
Hey, Joseph. Great question. Could it have been given back to Melly? I think in the closing, from what I saw, the prosecutor is suggesting that someone went and got his phone that may have been at Pembroke, which was the location of the shooting, and that's when he got and the phone was returned to him. For me, I have been following the phone. I call it FTP the whole time. And it looks like the phone was at the location of the shooting, and someone, or he went in, by he I mean Melly, got it back, or someone brought it back to him, and he resumed his business as usual. That's what it looks like to me. I've just been following the phone and going with the phone data.
Our next question comes from Nick Knox, 712 from Instagram. Terry, shouldn't the prosecution get more time than the defense in closing arguments since they have the burden of proof?
Well, the way our system works is they both get equal amounts of time. They do have that burden of proof, and because of that, they get an opportunity to do the rebuttal. They get that very last word. So that does give them a slight advantage. And I think what Christine Bradley did, and she did it well, is she laid out the case. She laid out her foundation for saying why she believes, one, that the shooting occurred inside that car, and why she believes, two, that Melly was the one in the back seat inside that car. She now gets a chance to hear what the defense has to say, and then she will get the last word. So she does get an advantage. The prosecution is given that advantage, and the advantage is the last word.
Threads question for you, Brian Buckmeyer. Southpaw Mac asks, after today, how much time will the jury have to decide the verdict in YNW Melly's case?
So thank you for the question. They would have all the time they want. No judge or prosecutor or defense attorney is going to rush them to get to that decision. Right now, I would say, as Terry Austin said earlier, they can even go into the weekend on Saturday. I would imagine they would have a week or probably 2 weeks at the very least until someone starts asking questions of, is this potentially a hung jury? Because it is a death penalty case, they're going to give them all the time in the world because if you do rush a jury or you do have any kind of influence on how or when they make the decision, that is an appellate issue, and you don't want that in a death penalty case.
Afi at Sundance JR from Twitter asks, why did YNW Melly send a drop pin to a friend to be picked up if the lone defense witness claims he was at home? Guilty.
So that's a good question. So then now we have to believe, was it Melly using what we now believe is his phone, that 9807 number, or was it someone else? Because remember, nobody on the defense side has admitted that he was using the phone and that he dropped that pin. That's just an argument that we've received from the prosecution. And it's also a very logical argument. Excuse me. It's a very logical argument. And again, the prosecution has done everything to point to the fact that that was his phone. He was using it. It was in constant use. We've got thousands of pictures and videos of Melly on that phone. So I think that, it's a great argument and a great position to believe that he dropped that pen and that it was him.
Terry Haley Perry from Facebook asks, why didn't they have Melly do a lie detector test or something of that sort?
That's an excellent question. Why didn't they also test him for, gun residue? They didn't do a lot as far as that's concerned. I'm not sure why they didn't do a lie detector test. That's something that's not usually admitted into court because it's not reliable, and they would prefer to, have reliable, credible witnesses on the stand or circumstantial evidence if they have it. And so the prosecution has used all of the circumstantial evidence that they have. They've done that cell phone tower. They've done the gun expert. They've done the DNA. They've done all of that, and that's how they're trying to prove their case, not with some lie detector, which most courts have ruled don't have the reliability to be introduced into evidence because you can just be nervous and it could seem as though you were lying. So I'm assuming that's why they didn't bother to do a lie detector test for anybody, frankly. But they should have done some gun residue and some other testing and clothing gathering and all the things that the defense is saying the investigation did not follow through with.
Yeah, the polygraphs are inadmissible in court, but cops use them as like an investigative tool to try to detect deception, and you have to consent to it. I'm sure Melly didn't give a statement. He's not going to submit to a polygraph. Jeremy Lopez from YouTube, Brian, what verdict do you think will be the most likely outcome, and why would you say the prosecution proved without a reasonable doubt that Melly is guilty?
So that's difficult, not seeing all of the summations, because if you had asked me this question before the prosecution did their closing, I would have leaned more to the defense. But now it seems that I think someone said it earlier, they've really put together all the breadcrumbs really well. But as a defense attorney, I think of reasonable doubt as a whole. The prosecution, the better they are, the tighter and smaller that hole becomes. However, I don't think that hole is completely gone. I do think the defense has the ability to poke some holes, and I'll give some examples. The reason why I say that is the prosecution did a really good job of logical statement, logical statement, logical statement, and then made a leap and said, well, this is what that means. And that was their entire summation. Now, if you want to make the leap with them, for example, he's a blood, and we show him talking about being a blood, and he's a part of the gang, and when he kills him, he now gets more venues and he gets more notoriety, and that's why he did it. Well, that seems like a very large leap to believe that's why he killed him, but the rest of that is logical. If the defense can open up that reasonable doubt, I think they'll do a very good job, but don't forget, the prosecution gets the last word, so I think right now it's anyone's game, or anyone's case. Sorry, it's not a game, it's a serious trial.
Afi, Jed Casey8 from Instagram asks, is the jury allowed to ask questions when deliberating, such as, why did the car stop and Melly get in? What was the reason for this? Or do they just have to make their own assumptions based on the evidence provided?
Oh, great question. I really enjoy jury deliberations because you can tell a lot about what they're deciding between, whether it's guilty or not guilty, or whether in this case it's going to be between the first-degree murder charge and the manslaughter charge. You're not allowed to ask any side to elaborate and to fill in the holes. The prosecution and the defense, that's their job before the jury gets their charges and before they start deliberations. But you can't ask, hey, the prosecution is required to prove this element of the crime. What does this element mean? Explain this or that to me with respect to the law, right? So explain to me what first-degree murder means. Explain to me what this element means in manslaughter. And when a jury asks those questions, usually each side can determine where their jury is leading.
All right, guys, we're going to take a quick break. Keep the questions coming in on all of our social media platforms. I'm Anjanette Levy. You're watching Law and Crime. Stay with us. We'll be right back.
Yay. He said, I'm tapped in. I appreciate you, bro. Yeah, it's been a lot going on with me. You know, here at the house. Also, been spending some time with family. Been on a long grind with this live streaming, man. So some of the content is going to be coming y'all way is going to deal with the live streaming world and, just life. Life as a whole. We're going to have some funny moments. We're going to have some panel discussions. All those type of things. Some giveaways. So, we in the planning stages of what this channel is going to become as well. I've had a blast watching this trial. It's the first trial I've watched in, I want to say, at least over a decade from beginning to end. In the midst of all this stuff going on, you remember, I got glasses now, so that's something I'm adapting to. It's been about a week. I think I've been wearing these glasses, so I'm getting used to that. But I do appreciate all the support, man. I'm, overly grateful and appreciative of everybody that tunes in. Make sure you hit that thumbs up, man. If y'all choose to, subscribe. Get those notifications so you'll be up to date with all the new content, all the new moves, any information. Because, putting out the information, that's a big thing too, because you can't do anything without the tools, you know what I mean? So that's what we on. That's what we on, fam. And I purposely am behind the actual footage.
Welcome back to the Lunch Show here on Law and Crime. I'm Anjanette Levy. We are taking your questions in the YNW Melly double murder trial right after the prosecution's closing argument. We are in a lunch break in the YNW Melly double murder trial, and when the lunch break ends, the jury will hear the closing argument from the defense. So keep your questions coming in. They're great ones as always, and we're going to answer as many of them as we can. Terry Austin, this one is for you. Janina43 from Instagram asks, either Davis or Glass were lying on the stand. Can one of them be charged with perjury?
Ooh, I like your question. Yes, I think one of them could be. And it's interesting because those are the two people who were in the red Mitsubishi, and they both testified. They were the only civilians who actually were witnesses as far as this is concerned, and they had opposing testimony. We heard Travion Glass talk about all four of the individuals who were in the red Mitsubishi came and left, and no one got in that car. And so it conflicts with what we heard Adrian Brian Davis say he also was in the red Mitsubishi, and what he said was the cars pulled over and Melly got into the red Mitsubishi. So what that jury is going to have to do is to determine who's telling the truth, and if the court wants to, they could charge one or the other with perjury. I think it'd be very difficult, though, because I don't know how the court would establish that either one of them was lying. They're both giving their recollection as to what's happening, and while they are, contradictory statements, I think it would be difficult to charge them with perjury at this point in time in any event.
Brian, this next question's for you. It's from Breezy West from YouTube. Why would Bortland sit inside the vehicle and let Melly shoot inside the vehicle while they were staging the drive-by?
Good question. Unfortunately, I'm not his attorney, nor do I know what he was thinking, but I'm guessing it was a surprise to him that he didn't see it coming, which, again, I think this came up earlier, lends itself to why not kill Bortland too? If you're surprising and shooting these other two people, did you have like a long conversation with Bortland where he like swore never to rat you out or whatever it may be? Why he did what he did at that time or why he said it was a drive-by shooting, I have no clue, but it's another thing that the prosecution can't prove, and if it's a burning question and goes to the heart of a charge, it could be an issue for the prosecution's case.
This makes me think about the damage to the Jeep, Brian, that front end damage. It's like, did it happen while the car was moving? I mean, that kind of leads you to believe possibly it did.
Yeah, maybe that makes a lot of sense, Anjanette. Maybe the shots went off, and like I'm assuming, like anyone else driving a car, you hear gunshots behind you, especially at that loud because it's inside the car, not out. You're gonna swerve. You're gonna go off the road. It makes sense that he could have crashed, turned around, and then saw two of the four people in the car bleeding to death.
Yeah. All right. Let's get to our next question. At @TheBull_21 from Twitter. If the cell phone shows that the car stopped Offie on Pembroke Road and US 27, why isn't there any surveillance from the fire training center or the waste management recycling facility?
I think it goes to the investigation. So, and it also goes to the fact that there may have been no surveillance in that particular area. When they requested their surveillance, it could have been at a point when those two entities erased the tape or they recycled the tape. Who knows? I'm assuming there was an absence of that evidence for the reason that it never existed or it was discarded somehow or it was never requested.
Let's get to this next question. Rhyme for Reason, from YouTube. Who did the third phone found in the Jeep belong to, Terry? Why didn't the detective investigate that phone?
Well, apparently that was a prepaid phone. So we had Anthony Williams' phone, we had Christopher Thomas's phone, and this one was a prepaid phone. I think they attributed that prepaid phone to Henry, if I'm not mistaken.
Yes, they did.
Yeah, exactly. And so my understanding is there wasn't much on that phone, and it wasn't anything that they were looking to find out from that phone. It was left in the car, and they ended up retrieving all three of those phones. If you recall the testimony, they said that the information on all three phones actually was destroyed, and so two of them, I guess, burned up, and the other one, the information just was no longer available. So they had those phones, but it didn't really provide them with any data inside the phone. They only knew about locations. They don't have any information as to what was in those phones in terms of messages, etc.
Yeah, and the one they attributed to Cortland Henry was, it was a minutes phone where you buy minutes, and it appeared to be out of minutes. Let's get to another question. Iona Quinn from YouTube. Brian, do you guys feel the state has given enough evidence for the jury? Seems like she's only basing he's guilty by the phone being in the car. We all leave our phones somewhere.
Yeah. I don't think at this point that, let me backtrack on this. It's a circumstantial evidence case, so I don't think we're ever going to get that direct evidence that says here he is, he did it, gun in hand, we've got it. They don't even have a gun, they can't do that. But what I think that prosecutor Bradley did do was shut off enough reasonable angles that this could have occurred. So the cell phones traveling together, reasonable to suggest that he's with them. They didn't verge off in different directions. He stopped at the location. She said, well, I believe that's when they started clearing up the crime scene and picking up the shell casings. She gave us enough to say, hey, most of these arguments that the defense are going to make aren't reasonable. The question is, can the defense come back and either elevate those and say, she's making a logical leap here, guys. She can't actually know this. That's just her impression. And you can't convict based on an impression. Or they can raise other reasonable doubts through other parts of testimony and say, this is why you should not find him guilty. I think there's still a little bit of reasonable doubt on the table, but prosecution always gets the last word. Maybe they can wipe that away.
Prosecution does get the last word, and the defense will have its turn after the lunch break, which ends in about 35 minutes here. And I know we're all looking forward to hearing what they have to say and where they go with this, other than, you know, they didn't prove their case, which they said in their opening statement as well, that they can't prove the case beyond a reasonable doubt. Guys, stay with us. We're going to take more of your questions after the break. Keep them coming in on YouTube, Twitter, Facebook, Instagram, TikTok, and Threads, and we'll get to as many of them as we can. Stay with us. We'll be right back. Hi, welcome to Law and Crime. I'm Anjanette Levy, and thanks for being with us on the lunch hour here on Law and Crime as we take your questions in the YNW Melly double murder case. We've heard the state's closing argument. It ended before the lunch hour, and court will resume at 1:30 in just a short time, and then it will be the defense's turn. YNW Melly, of course, is accused of 2 counts of first-degree murder in the October 26, 2018 deaths of his 2 friends, his lifelong friends Chris Thomas Jr. and Anthony Sackchaser Williams. He faces the possibility of the death penalty if convicted. And, you know, he has a co-defendant in this case, too. His name is Cortland Henry, and he will be tried later this year in October, and he is not facing the possibility of the death penalty. So let's get right to your questions. We have so many good ones coming in. Did Melly have any prior convictions, Brian Buckmeyer? If not, is that taken into consideration when sentencing?
You gotta, I think the answer is no, and please, Terry and Anjanette, correct me if I'm wrong. I don't think he has any prior convictions. If he did, it might come into, well, no. If he gets convicted and he goes to sentencing, I don't think a prior conviction would affect anything because he's either gonna get death or life in prison. If this was, for example, a violent felony where he wasn't looking at the death penalty but was looking at a range, let's say like 15 to 40 years, and he had a prior violent conviction or even just a prior conviction, his sentencing guideline will then shift and be a little bit higher. But because we're talking about death or life in prison, I don't believe that a prior conviction would really have an effect here because the sentences are already so high.
All right, and that really wouldn't come into play. That might come into play if we get to the sentencing phase. Obviously, the prosecution would bring that up. So that would be something that would come in then, or even if he's convicted of the manslaughter, it would come up then. They're not going to talk about that in the case in chief. Dee from YouTube, the prosecution hinted, Offie, at a weapon possibly being inside of the satchel. So is it possible that Juvie is a possible shooter as well? Were his hands tested for gunshot residue?
Yeah, there's a possibility that he was a shooter, but I do think the way that the accident reconstruction experts set it up, set it such that the person who was in the rear driver's seat was the only person who could have shot Anthony and Juvie. It was one, and it was also just one shooter. I do believe he was tested for gunshot residue, and he was positive for gunshot residue, but we also know that there are many ways that GSR can transfer. If you've been in contact with someone who has gunshot residue, it's easily transferred. If you're anywhere around gunshot residue, it's easily transferred and it's easily washed off. But I do believe the prosecution has set it up such that there was only one shooter, and it could have only been someone who was in the rear passenger seat.
Mm-hmm.
Rear driver's seat.
Yeah, you can just be standing. Yeah, you can stand next to somebody or in the vicinity, as you mentioned, of somebody firing a gun, and you're going to have gunshot residue on you. Jed Casey 8 from Instagram, Terry, what will happen if it's a hung jury? Will Melly go back to jail until a retrial, or could the prosecution choose to either drop the charges or offer a deal, etc.?
Well, it all depends. It's going to be up to the judge. If he is a mistrial in this case, then he could very well go back to jail, or he could be freed. The judge is going to have to make that determination based on what the parties are asking for. A mistrial doesn't mean he's guilty, and it doesn't mean he's innocent. It just means that the jury could not come to a unanimous decision, and the whole situation changes at that point, and the defense or the prosecution could say, look, I think that at this point in time he should be freed. The judge can say, let me hear from both sides. The prosecution can say, no, I think the original conditions remain, and the fact that, they think that he may be a threat, they will argue that, and then the judge will decide whether or not, he can walk out at that point in time. Now, I will say the prosecution will have to determine whether or not they're going to bring charges again. So if they determine at some point that they are not going to bring charges, he will go free. So they will have to make that determination at some point in time.
All right, this question, Brian, from TikTok. YNW Melly's defense saying he types dat with a D, different from that with a THAT. Is that good evidence? And this comes from Melly Lover 1.
I think it's good evidence. Melly, what was the name of the person? Anyways.
Melly Lover 1 is the person asking the
That's
question.
what I thought. Well, Melly Lover 1, I think it is a great argument. Anytime a defense can take what the prosecution is putting forward as a strong argument, that being, hey, after this, in a conversation with someone else, he texted, I did that, and try to make it seem like the context of that conversation was him giving an admission, the closest thing they have to an actual putting the gun in his hand and him being the shooter. If the defense can find a way to sow doubt into that, I think it's massive, because now you have the prosecution going headlong forward saying, this is it, this is the confession, this is what you all should be looking at. But the way the defense paints it and says, look at the way he speaks, look at other messages, it's clear this is not what this means. The prosecution has blinders on, it's a botched investigation, and they can go down the whole rabbit hole of the arguments they made during opening statements. I think it's a great argument. Whether or not the jury buys it, that's a different question.
I Dress and Rest from Twitter asks Offie, from what I understand, if Melly is convicted, he gets life or the death penalty, correct? I'm aware that Florida has no parole. I'm wondering if there are in-between charges that I might have missed. And so we kind of touched on this a little earlier.
Yeah, so I think the in-between charge may mean is the lesser and included offense of manslaughter. I'm not sure of what the minimum is for manslaughter in Florida. It's different by jurisdiction. By jurisdiction, I mean from state to state. So, but if he's convicted of manslaughter, then he will be sentenced, and then there may be an opportunity for parole for him. The only opportunity for the only chance where he would never see parole is if he gets sentenced for first-degree murder, and that's either death or life without the possibility of parole.
I just Googled while you were answering that, Afi, and it says that the maximum sentence for manslaughter in Florida is 15 years in prison and or a maximum fine of $10,000. So that's what Google told me about that. Okay, so our next question comes from, let's do this one. McGee_8789 from Instagram. Terry, so now that all the evidence is shown, the state still failed to put a weapon in Melly's hand. Will this play a huge factor in getting a good verdict?
Well, according to the prosecution, she thinks she has put a weapon in his hand, but not literally, because as we know, there is no gun in this case that has been located. So she believes that she's put the weapon in his hand because of the ballistics and the trajectory of the bullet. She's saying that it could have only come from the back seat on the passenger side, and she's saying that he got in the car and that's where he was sitting. So to your point here, I do believe that, you know, there is no gun, and if there was a gun, it would make it much easier for the prosecution. But she's making a leap, as Brian said earlier, that because of the positioning of the parties, that it was Melly who had that gun. I do think the jury is going to pause there. We've seen cases where there's been no weapon and you still have a conviction, and I think that is something the jury is going to be thinking about. Well, you know, I'm not totally 100% convinced, the jury might say, that there was a gun in Melly's hand, and you know, there's no gun residue. Whether they test it or not, there's nothing to really, beyond a reasonable doubt, say he was the one who did that shooting.
Melly Lover 2.0. I'm giving you all the Melly lovers, Brian, from TikTok. This is Melly Lover 2.0. I wonder if 3.0 is hanging out there somewhere. Why was Bortland let out when all the evidence is all to him, but Melly is sitting in jail and they have no evidence on him? So if Melly is found not guilty, can the state be sued?
I wish states can be sued for that. I'd be a very successful defense attorney, but unfortunately, no, you cannot do that. And to answer the first question, I believe the idea is that Melly, even though the prosecution kind of backtracked a little bit in their summation, Melly is the shooter based on the trajectory of the bullets, and that Bortland, YNW Bortland or Cortland Henry, he is not what we call the principal, not the one who's actually doing the shooting. He might have participated in some way, shape, or form, but he's not the actual gunman. So I think in that distinction, Henry was given house arrest because he was able to make the argument that he should not be within jail pending this case, and YNW Melly lost that argument because the evidence against him says that he is the shooter. I think that's the difference for the bail status or bond status.
Afi, this is from Instagram and the Bull_Rex. The prosecutor is saying Melly shot them and sent a pin to Fredo, but Fredo never picked him up. So where did Melly go when Bortland went to the hospital?
Well, we do know that a pin was sent to Fredo. We don't know for sure whether he picked him up or not. We've had limited testimony from people who were actually there immediately before, during, and after the murder. But from comments that I've read outside of the evidence that's been presented in court, he was picked up by Fredo and they returned to Fredo's house. But we saw in court, whereas according to the alibi witness, that Melly switched cars and was at home. And then later, everyone went to Fredo's house. So I'm not sure. I can't give you that answer.
Alrighty. Let's get to another question for Terry. This is from Blackberry from YouTube. Didn't Adrian Davis give a statement a year or two before stating the same thing he testified to? Didn't Travion say he was in the red car years ago, then changed after threatening jail time?
Well, we do know that Travion gave a prior statement because we heard the prosecution giving him information to refresh his recollection. So, you know, based on that, he had a prior statement, but he couldn't remember a lot of what he said in that prior statement, and she had to refresh his memory about specifics in terms of timing and whether or not Melly came home or he came to Fredo Bang's house. I don't remember hearing for Adrian Davis that he had a prior statement. He may have. If that's the case, I don't recall hearing him being asked about that statement and saying anything that's inconsistent. So if he did make the statement, he probably testified similar to what he said during that statement. And the real issue here is whether the jury is going to believe those two witnesses, because again, those two individuals were the ones who were there at the evening, and they had opposing, statements essentially on that stand. One said that Melly got in the car, that was Adrian Davis, and the other said, nope, Melly stayed in the car where he was because everybody was in the same car where they started out at the studio. So we'll have to see what the jury thinks about those two opposing views.
All right. Well, Terry, we are going to let you go and grab a bite to eat before court resumes at 1:30. So thanks for being on and coming on with us. Brian and Offie and I will be back in just a minute. So stay with us as we take this quick break, and we'll get to more of your questions. I'm Anjanette Levy, and you're watching Law and Crime. Welcome back. I'm Anjanette Levy, and thanks for being with us during the lunch hour here on Law and Crime as we take your questions in the YNW Melly double murder trial. That case, by the end of the day, will be in the hands of the jury. The state finished its closing argument right before the lunch hour, and at 1:30, so just in a matter of minutes, it will be the defense's turn to give its closing and make its final pitch to the jury in this case. So let's get to more of your questions while we have this little bit of time left. Scully Wolf from YouTube, Offie, will Melly be completely free if charged not guilty, or I guess they mean if found not guilty?
He's acquitted? Yes, he will be completely free. Period.
That was a quick answer, yeah. Not much explanation there, so the answer is yes. Carrie Trinan from YouTube, Brian, do you think the state proved without reasonable doubt murder? I think they did prove he was there, but not exactly murder. I need to know if I'm not crazy on this one. Do you agree?
Well, I'm just an attorney. You shouldn't take my diagnosis for being crazy or not crazy, but in this, I do not think you are crazy. I think there are enough holes here that raise enough questions. I think even from this Q&A, I'm seeing a lot and learning a lot from you all as to the very poignant questions that you have that are not being answered. And I think if the defense can tie those to any of the elements of the crime, because it's one thing to have a question and be like, well, why did YNW Melly get out of the car according to Davis? That doesn't really go towards the heart of the charge. But if you have a question that's burning and says, well, this seems to not make out murder, that's reasonable doubt, and I think there's enough of those that gives some people some pause.
Mm-hmm. Our next question I'm going to answer because it's one of my favorite things to talk about. It's fingerprint evidence. Jenny Dwyer from YouTube, wouldn't Melly's prints be on the door handle inside of the car because he got out? Okay. Here's the thing that I have learned about fingerprint evidence over the years covering murder trials. Fingerprints are created when the oils in your skin kind of leave that print on a surface that's suitable for prints. Some surfaces are not suitable for fingerprints, and so they're not always there. And fingerprints are very unstable. And this is everything I've always heard and learned from listening to fingerprint examiners testify in cases. So something like your iPhone, you can leave a print on there that might stay pretty easily. Something like a door handle, maybe, maybe not. And those types of things are just not always there. And sometimes they're not a full fingerprint like you see on a crime show. It's just a partial, and they have to have so many points in order to make an identification to a certain person. Keep in mind, in this case, the state says they have some DNA evidence on a door handle and that they also have surveillance video showing Melly getting into the vehicle. So there you have it about fingerprints. Offie, if you disagree with me, feel free to chime in, but I'm going to send this next question over to you. The Dope Game from YouTube, was Melly's phone ever tracked to the hospital?
From what I've seen, no, his phone was not tracked to the hospital. It was tracked to the Pembroke area, which is where the prosecution believes the murder happened. I believe it was tracked to Fredo Bang's house, and then it was tracked, of course, to where there was a video shoot after the murder occurred. So those for sure I know, but not to the hospital.
Alrighty, let's get to our next question. Pop out trail from YouTube. Brian, do you think the experts that testified are reliable since there were mistakes made during the case?
Ooh, how do I answer this properly? I think that they were reliable based on what they were given. It's like asking someone, what's the weather like in a place that you're not there? And I go to my app and I say, okay, in Kingston, Jamaica, according to my app, it's 95 degrees and it's really hot. Now, if the app is incorrect, am I reliable or am I not reliable? It all depends on what information is inputted. And so I think the defense can kind of walk a fine line of saying, we told you from day one this investigation was botched. It's maybe not the expertise of the expert that is incorrect, but the information that was inputted to the expert, and that's why the results are off. So I'm not sure if it's they being unreliable or reliable. It might just be that the investigation didn't provide enough for them to give the perfect answer or the most correct answer. I don't know. It all depends on the investigation. I don't think this was the greatest investigation in the world, so I do have some doubts about their finding, especially in the trajectory arguments they've made.
Afi Real with Robo from YouTube asks, did the prosecution present the facts well? Follow up, what would you stress as defense during closing to win the case?
I think during the trial, they piecemealed a lot. And I think that they're using their closing to, I think I said earlier, they're presenting us a hot conspiracy pie, and I think they're doing a very good job with that. I think the defense needs to focus on a lack of motive. We don't know, we don't understand why this person would kill two of his friends. We heard testimony saying that he's known these gentlemen since he was in middle school, in elementary school. They were friends, they lived together. Is money the motive? How much money was on the line? He was the earner. How much was he earning? So I think if I were the defense, I'd just hammer home on the why. There's no reason that the prosecution has presented. Even though the prosecution doesn't have to give us a motive, I think that that's what the jurors are going to want to understand.
I think the jurors always want to know the why. I mean, I think we all, as human beings, want to know the why, always. But as you mentioned, Afi, they're not required to present that. They're not required to prove motive. But it's helpful. And they claim, you know, Melly was getting 10 grand here, 15 grand there from Track. And SAC was asking him for money, and apparently there was $16 million going into Track's account. We don't know if that was all from Melly. We don't know if that was all Melly money. It could have been other things. We're just not sure yet of that. So our next question comes from Michael Jorgensen, Brian. And Michael is a frequent question asker here during our Q&As. Do you believe that the prosecution proved the gang qualifier? If they proved the murder, were they as well successful in proving he truly was a member and advancing the gang? I assume he means gang membership.
Yeah, the advancing the gang argument, even as she presented it in the summation, I felt like it fell a little flat. She had, I'm not going to do the sign, but she had him showing bloods with his hands like this. Okay, maybe that associates him with being a blood. Then she showed his participation or his association with the gang, and then just talked about things that benefited him afterwards, like him getting more notoriety or him getting additional venues. But he's a rapper. He's going to get venues. He raps in a genre of music where violence is part of their credit. It's part of their currency. but it doesn't mean that he did it to get that. Again, one of those logical leaps. And I don't, and even when the way she said it, it was kind of, oh yeah, like, and then he like got some other stuff too. I'm like, you don't even seem to believe it. So I don't think she proved it. I don't think she said it with enough force in her voice. And I think it's gonna fall apart, at least in that one little element of advancing the gang position.
I'm going to answer this next question really briefly. Daz Merchant from Instagram, did the prosecution make a mistake not trying both Cortland and Melly together? No, because Melly was facing the possibility of the death penalty, so they couldn't be tried together. And Cortland Henry is not facing that potential death sentence. So let's get to another question here. I had one for you, Afi, that I thought was pretty good for you. I heard a few contradictions in the state argument, such as Melly didn't want to leave any witness, but he didn't kill Cortland Henry. Does the state have this type of room for errors?
The state always has a lot of flexibility because usually jurors believe that if the defendant is in court and he's been charged with something, that there's a good reason that he's there, whether it's that he's guilty of what he's actually charged with or not is something else, but they definitely believe he has a reason to be there. I don't think that she did a great job advancing the idea that he didn't want to leave any witnesses. I also don't think she did a fantastic job explaining, again, going back to motive, we know that there may have been an issue between Melly and Sack, but why are we also involving Juvie in this? What is the motive to end his life? So I think there are a lot of questions that are left open, and she's asking us again to make a lot of leaps of logic. And, I think that leaves a lot to be desired on the prosecution side.
Mm-hmm. Instagram question from DJ Louie Lou. Brian, the defense witness stated the vehicles stopped at one point so Melly can get out and get into the other vehicle. My question is, how did they coordinate this? That's a great question.
From my understanding, and the prosecution brought this up as well, and I thought to myself, well, if two vehicles are traveling together at the same time and they're either close to each other or whatnot, you just yell from one car to the other. I mean, in college, I played college soccer, and we, in Queens College, didn't have the money to get a giant bus. We had multiple cars that drove us there, and sometimes you'd pull up to a light, and the other vehicle would pull up next to you and say, hey, these guys want to go get food. Do you want to go pull over here and get some food? And we did it. Now, if you checked our phones, would there be any communication as to why we pulled over to get food? No, but two vehicles traveling in the same place, they can do this thing called talking out the window.
Okay, so our next question. This is from Twitter, at SPNCOCE20. Will Fredo Bang, be charged with accessory after the fact?
I wildly doubt it. I think that his only interest from the prosecution's perspective was being a witness in this case. And I don't know for sure, but I've heard and I've read, and I'm only speculating that he pled the fifth, and that is the reason that he wouldn't testify, or he was offered immunity, but he couldn't be guaranteed immunity on a federal level or outside of the state. I'm not sure, but I certainly doubt that he's going to face any charges in this case.
Mm-hmm. Yeah, it seems like that would have already happened if they were going to do that. Let's see. If there is a hung jury, Brian Buckmeyer, do you think Melly will get a bond while waiting on a new trial? This comes from Brittany Garcia from YouTube.
Yeah, so there will definitely be the argument if there is a hung jury, and based on the numbers, either side would have a stronger argument. What I mean by that, if it's 9 to convict and 3 to acquit, the prosecution would say, hey, we were almost there. We were 3/4 of the way there, and so we at least feel that he is still a danger. There are civilian witnesses who could be tampered with. There are people who could be lost or murdered or whatever it may be. We want the remand or no bond or bail to be instituted. But if it's 9 to 3 or any kind of positive number towards acquitting, I think the defense has a very strong argument as to why he should be given at least some form of bond. You shouldn't be held indefinitely without the possibility of bail for most crimes. Many argue that murder, depending on the circumstances, would include that as well. So I think there's an argument for it. Whether or not the judge will agree, that's yet to be decided or seen.
All right, well, that's all.
Uh-oh.
Are they ready to go?
Yes. They were using the restroom, but
Oh, excuse me, one thing, lastly, before we bring the jury, the other thing I wanted to ask you was about the alternates. I'm not going to say how many sequestered, I'm just going to send them home, tell them they're not excused, not
Yes.
going to limit the papers, not everybody else hear that?
yes, they're ready.
You ready? Allison, are you ready?
Yes.
Judges, after Mr. Christine is finished, we could take a break and provide you with yours after the vote.
All right. Okay, Brandon. Let the record reflect the importance of our jury, defendant, their attendants, his counsel, the assistant state attorneys. Ladies and gentlemen, I trust you had a nice lunch. This is the defense counsel's opportunity to address you. Please give Mr. Adelstein the courtesy and attention that you previously displayed to Ms. Bradley. Counsel, if you're ready, you may proceed.
Is he a principal or a shooter? That's what the state address you folks just a few moments ago before you went to lunch. And the reason they said that is because they don't even know. Otherwise, they would select either him being a principal or the one who caused the death of Williams and Thomas. It's that simple. Where is the fire? Was the message. They say it refers to guns. That's their interpretation. My interpretation, based upon the evidence, is where's the weed, the marijuana? That's the problem here, folks. They're interpreting it as opposed to calling these various people to tell you what they mean. They mentioned Frederick Gibbons, Frito Bang, Mariah Hamilton, Peasy, Patrick DeLoach, Dontavius Withers.
Objection, Your Honor, Albert.
They opened the door.
Stay.
We don't have a burden. As the court told you in jury selection, the burden of proof is on the state. And the court told you during jury selection that this is a first-degree murder case, wherein the penalties are either life without the possibility of parole or death. You folks are going to determine this young man's fate. And they come in here and give you alternatives. They come in here and give you their interpretation when we don't have to do a darn thing. And that principle was so important that His Honor read you that instruction at the beginning when you were going through the process. That he just read it to you before the state got up and gave their opening and closing statement. He told you that this young man has pled not guilty. That means you have to presume him innocent. That means that that presumption stays with him until and if the state of Florida can prove their case beyond and to the exclusion of every reasonable doubt. The judge goes on to tell you, and it's in your packet of jury instructions, that the defendant, Jamell Melly, is not required to present any evidence or prove anything. So it's nice that they're interpreting these things, but the bottom line is they don't even know. Because they've given you just two alternatives. Either he's the shooter or the principal. Make up your mind. Tell these folks what it is. Now, how do you go about doing this? Well, the judge gave you an instruction on that. You're to look at the evidence that's been presented to you. Remembering, we don't have to do a thing. All we have to do is show up and behave. Now, I don't know if I behaved totally correct during the course of this trial. So, on behalf of us, let me apologize if I have or we have offended any of you. And I would ask you, I would plead with you, if I or any of the other individuals have done anything to irritate you, don't take it out on this young man. Still hold the burden of proof to this table. Now, why do they have the burden of proof? Because they are the state. They are the government. As we learned in this case, they have the police department of Miramar. They have the Broward Sheriff's Office. They have the DNA labs. They have experts, the FBI. They have everything at their disposal. And that's why our system of justice is different than anyone else in the world. We recognized a long time ago that when the government accuses somebody of a crime, they have the money, the resources, and the person power to attempt to prove to you all that a person has committed a crime beyond and to the exclusion of every reasonable doubt. Now, how do you go about doing it? And before I get into that, first of all, let me also thank you, because we have interrupted your lives for it seems like months. And we have put a horrible burden on your personal lives, your family life, and what have you. And all of us applaud your and thank you for your service. You folks have gone way beyond the call of duty. And I think we all recognize that. But how do we go about determining, and I shouldn't say how do you folks go about determining if the state of Florida has proved their case beyond and to the exclusion of every reasonable doubt? Well, the judge just gave you that instruction. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. Remembering, we just got to show up. And how does a reasonable doubt occur? Well, the judge has told you. It can come from the evidence itself, a conflict in the evidence, or a lack of evidence. You don't need all three of these areas. But I suggest to you folks that we have a reasonable doubt from the evidence that has been presented, that there is a conflict in the evidence, and there's a lack of evidence. This is an unusual case, kind of like the medical examiners. The two medical examiners said it's unusual because normally you can't tell what shot occurred first, second, or third. And the chief medical examiner came in here, Dr. McDougall, I think, and told you it's only happened to her in her entire career, I think 2 or 3 times, that she could tell you which shot occurred first in this case. So, knowing that, let's look at what the state presented. But before we do that, we can agree upon a couple of things that are not in dispute. They said that Matt Melly is a talented music artist. We agree with that. At the age of 19, based upon the evidence, he was making more money than probably everybody in this courtroom, including us. Number 2. Oh, I'm sorry. I apologize. You okay? Usually, the judge will stop me immediately. Number 2 is that Cortland Henry changed his clothes before he went to the hospital. That's what they said just 10 minutes ago. Number 3, that there's absolutely no eyewitness that will implicate this young man to this crime, these crimes. Number 4, they talk about premeditation. I suggest to you there is absolutely no evidence whatsoever to show premeditation. And the last one that we absolutely agree with, and they admit it, the Miramar Police Department lacks the training. Those aren't my words. That was Miss Bradley just an hour ago saying. Not only did Miss Bradley say that, but Sergeant Williams also said they lacked the training in one of the worst investigations. That's why I pushed aside their reports. Now, the state produced over 100 exhibits sitting right here on the floor. Ms. Bradley made reference to some of them. They're all here. And I put them on this side of the podium because I suggest to you that this is a smoke screen. I suggest to you that this is open for anybody to interpret any way they want. When I say something sarcastic, you don't know if I'm serious or not. I can tell my colleague, I hate your guts, and it could be joking, and I am joking. And that's what this case is, and that's all this evidence is open for interpretation. That's not evidence proof beyond a reasonable doubt. Now I put on this side of the table really the evidence that means something. There's one other exhibit, but it's on a little USB internet thing. And that is the video leaving the studio, showing the 2 cars and the 8 individuals that left. Sitting on this side of the table is a broken cell phone that Moretti could not tell you whose it was, and the 9807 phone that Melly uses, as other people do too. These are the 2 key pieces of evidence. These are what I suggest you focus in on, because you can take any one of these items, any one of these text messages, any one of these pinging on maps, and you still don't know what was said, what was meant, and more importantly, who said it. I leave my phone, and I'm sure you all, in the house, and my wife picks it up and sends a message. And it looks like it's coming from me. And sometimes she sends messages that I'm kind of shocked about. But it's, you don't know. So let's put the 100+ exhibits to the side for a moment. The state called 26 witnesses. I think I counted. And I suggest to you that you should look at 11 witnesses very carefully. And why do I say that? Because when you look at these 11 witnesses, you will find out that there's a conflict in the testimony, that there is a lack of testimony, and the third way is from the testimony itself. The first one that I would like to talk about well, before I talk about the first witness, I want you to remember one thing. On October 26th, that day of the shooting, we learned immediately that that Jeep was taken to a secure area. And it was searched for over 15 hours by 2 crime scene technicians. And you heard how they pulled out the evidence. They got some foam, some projectiles, I think a can, everything, and photographed the vehicle. Now, why is that important? Because that vehicle was searched. Are you okay? Want to take a break? That vehicle was searched again months later. But it didn't stop there. Because about 3 years later, miraculously, even though it was searched for hours by crime scene technicians, Sergeant Williams comes into the scene at the request of the state of Florida, this particular prosecutor right here, and miraculously he finds additional evidence, 2 projectiles and a bloodstain that obviously everyone else missed. That should tell you something about the quality of this investigation. That should give you a clue as to what's going on in this case. What happened was, once they got the surveillance tape of the individuals leaving the studio, they knew that Cortland Henry, Williams, Thomas, and this young man got into the Jeep. It's shown on the video. In the Mitsubishi were Adrian Davis, Patrick DeLoach, Trevon Glass, and I'm missing one other one. Withers, Dontavius Withers. And we know that on October 26th, when Moretti saw that surveillance, Cortland Henry identified all of them. And in fact told them that he lives at this young man's house I made a mistake. Jacoby Mills was in the car. It was Jacoby Mills, Adrian Davis, Trevon Glass, and Dontavius Withers. Okay? I can't keep the names straight. I'm lucky if I can remember my own name. That's why I haven't written it down. We know that Moretti identified all 8 people that left the studio on October 26th. We also know that Moretti knew where this young man lived, along with all the other 7 people that left the studio. We all know that, according to the state, Cortland Henry lied to the police. And we also know, as the investigation progressed, that Cortland Henry had blood matching the victim on his clothes. And he also had GSR, or gunshot residue, on his clothes. If that were true, and you saw the pictures of the Jeep, all bloody, blood all over the place, and we learned that you could spray and determine if there was blood right here on the carpet, even though you don't see it, why in the heck don't you get a search warrant for the house? Why in the heck don't you? Don't tell us we didn't know where he lived. Don't tell us it was months later, because they go into the car 4 years later and do this. So why don't you do it? Because Detective Moretti and the Miramar Police Department, as everyone has said, lacks the experience and the training. We don't have to do a darn thing, folks. We don't have to do a thing. But let's go into the 11 witnesses now. The first one, and they mentioned it, George Bello, the manager, the head guy of the gun and tool mark unit of the entire Broward Sheriff's Office. And he tells you, after we get a great education of guns and projectiles and casings, we have to bring out the fact that can you tell or determine the distance between the shooter and the victim? Can you tell us that with all your experience? And what does he say? I can't do it unless I have the weapon unless I have the ammunition, because ammunition, the weight of ammunition, could change the distance. And you have to have the weapon in order to do that. He cannot even tell us if it was 1 gun, 2 guns, or more. He's honest. He tells you that without the weapon used, I cannot place the shooter to the victim, or victims in this case. Now, why is that important? Because a reasonable doubt can arise from a conflict in the testimony. If you believe George Bello, and I suggest you should, then he totally contradicts all the testimony of Sergeant Williams, who comes in here 4 and 5 years later and says, I can tell you where shooter 1 was, and I can tell you who the shooter is. You talk about a conflict in the testimony? It's one or the other. It can't be both. And he tells you, in addition to that, that the environment has to be considered. Now, Williams tells you he goes out to the scene some 4 or 5 years later and has no idea, nor did he even check the terrain, the environment on that particular morning hour. So you got to believe one or the other. You can't believe both of them because they are in direct conflict with each other. But let's go further. The next witness that you should consider is FBI agent Brendan Collins. He is an expert in tracking phones. He is not only an expert in Broward County, but he's an expert, and his team have been specially trained to map phones, not only in this country, but anywhere in the world if he's called upon. They brought him in. And what does he tell you? This expert. I cannot determine precisely the location of a phone. I cannot say 100% the phone is in, and you saw the band, it looks like a banana. He says, I think it's somewhere within this area, but I can't be 100% sure. He's candid with you. And he further tells you that the call detail records are limited. And I can't tell you who had the phone at any particular time. And most importantly, he tells you in making the mapping of the phones, the FBI, the special agents, do not use 2 items that are on the bill. That is the environment section, and he does not map out based upon the longitude and latitude. He goes to the cell towers and where they're bouncing off. And it could vary depending upon the strongest signal or how busy that network is. Well, he contradicts Williams, the one who comes up and tells you the phone is at this location here, this location here, this location here, at these particular times. It's one or the other, folks. I suggest you there's another conflict in the testimony. The next witness I think you need to pay particular attention to and really get a flavor of what this case is all about is Felicia Holmes. Felicia Holmes tells you that the Miramar detectives, Moretti and his group, threatened her, bullied her daughter, told potential witnesses they were going to prison, told witnesses that they may never see their children again, told a witness that he was going to be deported even though he's been in this country since 5 years old. He was going to be deported to Haiti where they won't feed you. The place is, with all due respect, and excuse my language, but it was his language that he used, shit. This is the great detective. This is why this kid's sitting here. They have intimidated and threatened everybody. So I ask you, I beg you, to consider Felicia Holmes, because that tells you what's going on. When Moretti got that surveillance tape and realized this young man, this little kid, excuse me for calling him a kid, he was 19 at the time, was a rap star, making more money than he'll ever see in his entire career at 19. He got tunnel vision. And he wanted to nail this kid. And what better way to move up the ranks, get some publicity, is to arrest a star. If they arrest Howard or myself, they go, who the hell is Addleston? Who the hell is Howard? That's the bottom line. So he just focused in, and everything was directed to get this kid. That's why he ignored everything. And that's why he intimidated and threatened anybody that said something different. So I ask you to pay attention to Felicia Holmes, because you do get an idea of what this investigation is. The fourth witness was Kurt Rhodes, the DNA expert. Now, why is he important? Because while we were picking a jury in April and we were off in May, this prosecutor asked him to go back to the car and check some DNA. Now, why would you do that? The case, according to Moretti, is closed as soon as this young man is arrested. Why do you go back 5 years and ask an expert, a DNA expert, to do some more testing? This kid walked into the Broward, voluntarily surrendered. And 5 years later, they had the audacity to say, do a little more testing. Why? Because now we're in trial. And they realize there's problems in the case. Why else would you do it? Three years after this young man surrenders, they bring in Danny Polo. I call him the masked man. He came in here for a few hours, if you recall, got on this witness stand and wore a ski mask over his entire face where you could only see his eyes. They came in here. He got involved in 2022 at the request, again, of the state, the prosecutor. What was the purpose of that? The great gang expert? They wanted to link him to some gang. You know, in the rap culture, whether you want to accept it or not, gangs are attracted to it. If you want to be successful in rap music, you are going to pick up some of the nuances of various gangs. Snoop Dogg to this day. It was. Oh, fine.
No problem. Yeah, ladies and gentlemen, this is argument. All right, just proceed, counsel. Objection those overruled.
Snoop Dogg to this day does hand signs of a gang. And he does that because he realizes it promotes his music. That's the bottom line. And because he wants to promote his music, make money, he's all of a sudden this big gang guy. And they wait till 2022 to bring him in. I thought the case was closed, according to Moretti. And they show you some text messages from, I think it was Gino Herc and Quando Wando, who fought with Anthony Williams previously. Now, certainly, the investigation is being fair, and you want to find who was involved in this case. You would relay that information to the lead detective of people of interest or suspects. And what do we find out? Moretti has no idea who Gino is, no idea who Herc is, and doesn't know about Quando Wando. This is the great investigation. But he also refers to some text messages where those individuals that are in fact associated with the gang text him and he's not responding. And to the point of not responding, they say they're going to put you on the plate. Now that's not for dinner. That's not for breakfast. We learned what that means. If you don't start responding to us, we're going to have you killed. What the heck's going on? Why wouldn't you investigate this? They want you to believe that there's no evidence of that. How do they know there's no evidence if they don't investigate? They don't search. They don't look. You got all these phones, yet Gino and Herc, you have their text messages. Go get their phones, track them, and see. We don't have to do a thing, folks. The presumption of innocence stays with us during the entire trial until and if they can prove beyond every reasonable doubt that this young man did anything wrong. Moretti didn't want to look at that. Why? Because God forbid they find some evidence. His arrest of a star is down the tubes. That's the bottom line. I want you to pay particular attention to Dr. McDougall and Dr. Saunders. Because those two doctors, one being the chief medical examiner of Broward County, the other one an associate medical examiner, I think now employed in West Palm Beach, say to you that the first shot to Williams and Thomas were fatal, deadly. Why is that important? Because according to Sergeant Williams, Thomas's injury to his hand came first. It was a defensive wound. We know that couldn't happen based upon the medical testimony. So you either have to disregard the medical examiner and accept what Williams' testimony is, or I suggest, now that you have three experts four experts contradicting Williams' testimony. And that is Bello, Special Agent, FBI Agent Collins, and two medical examiners conflict with Williams' testimony, that you should take Williams' testimony and ignore it, toss it out. You can't have it both ways. It just doesn't work. And then we get to really their star witness, two star witnesses. Sergeant Williams. And I think I've talked a bit about him. And I think the most amazing part of his testimony is that he does not get involved in this case until 3 years after the incident. Again, at the request of the state. Again, because they realize they have problems. And I applaud them to recognize they have problems. And miraculously, as I told you earlier, even though the Jeep was searched for hours and hours, processed for hours and hours, he finds additional evidence. 2 projectiles that everyone else missed, and a blood stain that is important. And that when he did his analysis, 2 important things occurred. He didn't go in there blindly to do any analysis. He told you that the prosecutors in this case told them that the defendant in this case was this young man. And we need you to do a trajectory analysis to put him on the scene. Now, I suggest to you, you could have a Jolly Green Giant and a midget. And if you give them the dimensions, the height and his arm length, with this mathematical formula, you could say the Jolly Green Giant or the midget was a shooter in this case. They would either be closer to the car or further from the car, depending upon their size. If you want to do an analysis, if you want to do an investigation, if you want to figure out who the shooter is, why do you point to this kid and tell him, this is what we want? Why do you do that? This is the great investigation. This is what they want you to do in order to render a verdict that could take him.
Over, proceed.
And tell him that he's going to live life in the state penitentiary without parole or be on death row. This is the investigation they want you to rely upon and say it's proof beyond and to the exclusion of every reasonable doubt? I guess so, according to them. And they call Danny Benitez. Who the heck is he? He was on the stand for all of about 2 minutes. Danny Benitez gave Detective Moretti the surveillance tape from the Montessori school. You watched it. It showed, I suggest, nothing probative to implicate this young man in it. But we learned, not from him, but from Moretti, that he doesn't go to the drugstore on Miramar Parkway to check their surveillance tape. He doesn't go to Applebee's to check their surveillance tape. He doesn't go to Polo Tropical or the gas station or the bank on Miramar Parkway to check their surveillance tapes. When the car's on 184th Avenue, he doesn't go to the fire station to check their tapes, surveillance tapes. Doesn't go back to the two elementary schools, Sunset Lakes and West Broward Elementary, to check their surveillance tape, because he knows it all. He knows it. How do you know it if you don't check? How do you know something unless you investigate? We don't have to do a thing, folks. We don't have to do anything except show up. And begrudgingly, we did. Where the Montessori school was, on Pines, there was a tractor supply company and another school. Why don't you get that? And come in here and say, you know what, folks? We checked all of this. Instead, what they do is take a helicopter ride 4 or 5 years later. And we have to sit here and watch as they fly the route. And we have to watch how they drive the route. Not checking what the traffic conditions were that day, back 4 or 5 years ago. Not checking what the weather was 5 years ago in October 26th. What's the purpose of that? Just to add more of what I suggest is a smokescreen. You look at all this and say, heck, man, 100 exhibits, 500 photographs out of a cell phone, all these text messages. What does it mean? Hopefully, for the state, you'll say, hey, where there's smoke, there must be fire. And say, hey, too bad, young man, too bad. There's a lot of stuff sitting here. And hopefully you will not fall into that trap. And then we get to the lead detective. Well, before we get to the lead detective, I think I missed someone. Trevion Glass, the individual who got into the red Mitsubishi. The man who is convicted of 2 felonies. Now, why is that important? Because the judge read you an instruction on some of the factors to look at in determining whether or not to believe a witness or not. And he told you that one of the factors to look at is whether or not the witness has been convicted of a crime. Trevion Glass, the state calls, as their star witness, basically, to say Melly never got into that red Mitsubishi. And he told you one interesting thing. He said he's got a case pending right now, and he doesn't want to go back to jail. Now, who has the authority to put him in jail? We don't. There's only one person who can put him back in jail. And that's the state of Florida, whether it be through the state attorney's office or the police department. And he miraculously is the only witness that says no one got into the red Mitsubishi from the recording studio. But he tells you, doesn't tell you how he gets into Melly's house, because he doesn't have a key. So What's going on here? What's the story here? And then they call the star witness, the lead detective, Detective Moretti. We know he doesn't look at the surveillance tapes on the various Miramar Parkway and Pines and what have you, because he knows. He's worked the area. He knows that he got 9807, the phone that Melly has used, and you've seen various and a lot of photographs. I think it's Exhibit 115, am I correct? 100, excuse me, 100. And who did they get this phone from? Detective Moretti? Jameson Francois. And certainly you asked him, how long have you had this phone? And he says, I never asked him. How convenient. And he goes and says there was another phone in the vehicle, but it was broken. That's 115? 115. So I can't tell you whose phone that is. Now, we don't have a burden to do anything. If you recall, we asked him to take out the SIM card of this broken phone. And there was a reason for it, to tell you the quality of the investigation. He took out that SIM card, read the serial number from that SIM card, which he had never done until you saw him open his phone in the courtroom. And he agreed that you can take that serial number to T-Mobile, Sprint, and what have you, and determine whose phone is, who is the owner, subscriber, and get a warrant for that phone. You've gotten warrants on a lot of phones. Get a warrant on this phone if you want to see what it is. Moretti doesn't want to do that because he's afraid it'll ruin the investigation. That's why I put these two phones separate and apart from all this other stuff. Now, the state said to you there was no reason, I think was the exact quote, for the Jeep to stop on the side of the road. I suggest to you that as we have done periodically through this case, the reason was...
Objection. That's not evidence.
Again, ladies and gentlemen, this argument. Proceed, counsel.
The reason was because you needed a bathroom break, just like you and I did when I raised my hand or stand up. And at 3 o'clock in the morning, 4 o'clock in the morning, if he needed a bathroom break, in the dark highway, and you saw him carry it in his hand, he'd leave it on the seat of the car. And we know that the car sped off because there was another car waiting, the red Mitsubishi. You want to know there's no reason? The poor kid had to urinate. And the phone was in the car. But they don't want you to know any of this. That's why we had to call Adrian Davis. But let's stay on Moretti for a little while. Because they take execute a search warrant on his house, his apartment, and his storage unit. They find ammunition in there. They find in the storage unit, I think, 3 holsters and gun locks. We don't know what type of guns belong to those holsters. We don't know what type of guns were the gun locks to. All we know is there are 3 guns missing based upon the 3 holsters. And Moretti doesn't even ask where these weapons are. What are these weapons? Should it concern you? Yes. Should it show you a lack of evidence? Yes. Ask yourself. They keep telling you to use your common sense. Use your common sense, please. Ask yourself why a lead detective of a double homicide would not ask Jameson Francois, where the hell are the guns? Where the hell are the locks that belong to the guns? Where are they? I suggest to you when you use your common sense, you're going to say, he doesn't want to know. Because God forbid, those or one of those could be the murder weapon. And then the investigation of this rap star is down the tubes. He reads to you various messages from various people. But he never goes to talk to these people to see what they meant. You search Jameson Francois' car that supposedly is involved in taking Melly. And 4 months later, well, if you go and search his car, Jameson Francois, let's go back again to his house. Get up here, State, and tell him why you didn't search the house. You learn about Frito Bang, supposedly takes him somewhere. Why in the heck don't you search his house? Even if it's 4 months later, 5 months later, 10 months later, and use that fancy spray. Not the one that causes you to get sick, but the new spray. And look for it. What kind of investigation is this when we're talking about putting a young kid on death row or life without parole? Or any investigation? This is no game, folks. We're playing for all the marbles. That's why they said that Miramar Police Department lacks the training. They did absolutely nothing once they got that surveillance tape. Blinders on them. We're not going to look to the left. We're not going to look to the right. We're just going to direct everything to this young man. And I'm glad they admitted the suspects of 13. We know that Cortland Henry's involved. You heard about Crucial Almighty David Hedgepath, who wrote and texted, "We killed 2 of you." And someone said I should use the word ninjas instead of the word that he used. And in that message, he had a target over someone's face. Whose was it? Guess what? It's Melly. And he did it within hours. And what do? Nothing. Years later, they get his so-called timesheet where he was working. They don't bother to talk to any of his co-employees to verify this. In fact, if you look at the timesheets, it gives him time to, I think he's up in Verrill, Melbourne, to be exactly in Broward County, which is about 2 to 3 hours before the job. It's no alibi at all. But why don't you talk to these people? Why don't you investigate? How in the hell does he send out a text? "We killed 2 of you. We were aiming at the Jeep." Bentley, who had a problem with Melly, he does nothing. That's not a person of interest. He knows that there is a incident at Walmart where he's robbed of a chain, I think it is. Why don't you get the surveillance tape? Or at least try so you can say, "I tried," and it doesn't exist anymore. Jameson Francois with the missing guns. He's the manager who had, I think, $16 million in his account. If anyone had a motive in this case, it would be Jameson Francois, possibly. I don't know. We don't have to prove a darn thing. Why don't you at least investigate? Why don't you do the work that is required before you ask 12 of you to either put him on death row or life in prison? Jay Green, who had a beef with Melly. Why don't you check him out? Quando Wando, why don't you check him out? Gina, who said he's going to be on a plate. They're going to kill him. Moretti says, "I don't even know who the heck Gino is because no one told me." Herc says you got to communicate with us or you're going to pay the consequences. He doesn't know who Herc is. Goon, same thing. And then the state rests. They say, "Folks, we've presented you all the evidence." Well, that wasn't true, because we had to call Adrian Davis. And you learned that Adrian Davis showed up in the state attorney's office and gave a sworn statement. They never told you this. We did. We don't have to do any of this. And Adrian Davis said, "I told you he got in the car." How do I know that? Because I was woken up when someone was crawling in the back seat. How do I know that? When we got to Melly's house, he's the one who had to open the door. Because only he and Cortland Henry had the key. to his house. Why do we have to do that? Why did they conceal that from you? Why did they hide that from you? I can't answer those questions, folks, but I don't have to. Other than to say, reasonable doubt. You know, when we started this journey together, the state promised you that they were going to prove their case beyond to the exclusion of every reasonable doubt. They told you that they have accepted the responsibility, that they have the burden of proof. They told you that they would prove each element of this case. What they have proved to you is that Cortland Henry is involved in this case. Who else, if anyone else, you folks don't know from the evidence. They tell you and play you a video where Melly appears in Cocoa Beach that afternoon. Well, as AD told you, there was a contract and people were going to lose a lot of money. And he happens to be at the tender age at that time of 19, a professional. And we all know, and unfortunately, probably a lot of us have had to do something while we are suffering an illness or a death in our family. What does that prove? Absolutely nothing. Other than at the tender age of 19, this kid, I say kid, I shouldn't say that, this man, young adult, is a professional. They say because you didn't show up at 1 or 2 jobs, that what the heck? They have no idea what the contract was. They have no idea how much money was involved. They have absolutely no idea. Why? Because there was no investigation. Play this. And they want you to believe that he's a cold-hearted murderer. When quite to the contrary. You saw the tapes. You saw that he's a nice young man and a professional. Folks, the worst thing any lawyer can do is sit and see a misjustice, no matter what side of the fence you're on. Especially when you're talking about a 19, now 23, 24-year-old kid. Man, young adult. To me, he's a kid. Because I have children older than him. The worst thing you can do is sit and see a misjustice. And we have sat here for months, starting in April, waiting to see the evidence. And I suggest to you right now, you should have more questions than when you were selected as jurors as to what really happened. And there was a gentleman who recently said that our system of justice is broken. I don't believe that. But he got on TV and it was all over national news saying, I think our system of justice is broken. you want to do justice in this case, and you want to follow His Honor's instructions of proving, making the state prove their case beyond and to the exclusion of every reasonable doubt, you will go to the verdict form and check off count 1. We, the jury, find as follows to the defendant: not guilty. We, the jury, on count 2, find the defendant not guilty. You may think he might be involved. That's not enough. If you waver and vacillate, that's what reasonable doubt is all about. You want to make sure the justice system stays intact. There is only one just verdict based upon the evidence they present. And that is, state, we just can't rely upon this beyond and to the exclusion of every reasonable doubt, because there is a lack of evidence, there is a conflict in the evidence, and the evidence itself and the investigation itself stinks. I'd use another word, but I would probably get held in contempt. But I think you know what it is. So say we all.
Counsel, thank you. Ladies and gentlemen, we're going to take a short recess. The case is not being turned over to deliberations at this time. Remember the admonition, you are not to discuss the case. Don't form any opinion about the case. Don't allow anyone to discuss the case in your presence. Certainly no research. Just leave your notepads and your jury instructions on your chair, please. Thank you. Let the record reflect the urgent speakers, Councilman Manuel, all the defendants. Do you restroom break? Yes. Do we arrange that for Mr. Dennis?
Thank you. May I say?
Anything to discuss? No? All right, we're in recess. Thank you.
This is the great investigation? This is what they want you to do in order to render a verdict that could take him?
Suggestion. Over. Proceed.
And tell him that he's going to live life in the state penitentiary without parole or be on death row? This is the investigation they want you to rely upon and say it's proof beyond and to the exclusion of every reasonable doubt? I guess so, according to them. And they call Danny Benitez. Who the heck is he? He was on the stand for all of about 2 minutes. Danny Benitez gave Detective Moretti the surveillance tape from the Montessori school. You watched it. It showed, I suggest.
Hey, real talk though, you pick Snoop Dogg of all people as an example, somebody that actually was on trial for murder and actually is a gang member. Like, what? That wasn't a analogy or reference.
Nothing probative to implicate this young man in it. But we learned, not from him, but from Moretti, that he doesn't go to the drugstore on Miramar Parkway to check their surveillance tape. He doesn't go to Applebee's to check their surveillance tape. He doesn't go to Polo Tropical or the gas station or the bank on Miramar Parkway to check their surveillance tapes. When the car's on 184th Avenue, he doesn't go to the fire station to check their tapes, surveillance tapes. Doesn't go back to the two elementary schools, Sunset Lakes and West Broward Elementary, to check their surveillance tape, because he knows it all. He knows it. How do you know it if you don't check? How do you know something unless you investigate? We don't have to do a thing, folks. We don't have to do anything except show up. And begrudgingly, we did. Where the Montessori school was, on Pines, there was a Tractor Supply Company and another school. Why don't you get that? And come in here and say, you know what, folks? We checked all of this. Instead, what they do is pick a helicopter ride. 4 or 5.
Christine Bradley mentioned that witness Felicia Holmes hates her, but it's her job to prosecute cases.
Yeah, I mean, you know, as a former prosecutor and yeah, I occasionally do defense. You know, I'm very I'm
ready to proceed.
Yes, Your Honor.
How about you, Mr. Is all
Yes.
set, guys?
Yes, sir.
All right, let's bring jury. Defendants, his counsel, the assistant state attorneys, as well as the ladies and gentlemen of the jury. Ladies and gentlemen, this is the state's opportunity to address you. It's referred to as a rebuttal argument. Please give counsel the same courtesy and attention you previously displayed. Riley, you may proceed.
Ladies and gentlemen, you've heard an hour and 10 minutes of speculation. You've heard an hour and 10 minutes of asking the state to do something I'm not allowed. I'm not allowed to testify. I'm not a witness. So why the personal attacks on me? Why getting upset when there's a mistake that was caught? Just like defense counsel made a mistake and Ms. Liberty quickly brought it to his attention that he said the wrong person and read Mitsubishi. There's a reason why there are multiple layers in place, why there are piece after piece of evidence that shows this defendant did that. Let me start in the back seat of that Jeep. How do we know the defendant was the one there with that Apple iPhone, not that LG? Well, here's a pretty good clue. Apple phone charger going to the back seat right there, not an LG. And also, ladies and gentlemen, you know that LG phone wasn't working on October 26th of 2018. Multiple witnesses testified that it was an inoperable cell phone. So let's be very clear on that. Let's talk about Adrian Davis, AD. Adrian Davis seems to be a part of this puzzle. Kind of looks like the other puzzle pieces, kind of looks like it might fit. But then when you put all the puzzle pieces together and you start looking and comparing it, you go, well, none of the other ones are bright red like that. It kind of sticks out like a red herring. Because that's what Adrian Davis is. So why would counsel ask me why I wouldn't call him? That assumes the witness is credible. That assumes the witness is telling the truth. That assumes that Adrian Davis's testimony is consistent with every other sworn statement, deposition, and trial testimony in this case. If the witness is not credible and doesn't agree with any other piece of evidence in the case, I'm not going to call him. So, counsel made a very, very big deal about the key, right? And why changing cars is going to the same place. Well, here's a message from September of 2018 between Mr. Demmons and Anthony Williams. Is the back door unlocked? Yeah. Well, it gets better. What about this one, where Mr. Demmons is asking, oh, does Bort have the garage button? More than one way to get into a house. And even better, from Anthony Williams, October 3rd, I would have told AD to leave his key. This is all in the messages that are in evidence. So that is on page 248 of the conversations between Mr. Williams and Mr. Davis. October 3rd, 2018. Tell AD to give you the key. Adrian Davis had a key. There's no question based on these messages. If you're going to make the argument, know the evidence. Because that is clearly contrary to all of the evidence on that. So, that's that community phone everybody used on that. I agree that the 9807 phone is accurate because it doesn't have any emotions, feelings, can't be paid off, it can't be in any way, shape, or form changed. It is what it is. So, to make sure that we're clear on all the aspects of the jury instructions, and Ms. Smith, I'm going to kind of to turn that on. Does the witness's testimony agree with the other testimony or evidence in the case? Counsel wants you to look at each piece of evidence individually. The problem is it's not an individual picture. It's the totality of the circumstances. Because if you look at each individual piece of evidence, what are the odds? Ask that question. What are the odds that Mr. Demmons got into that back seat? That all the fatal shots came from that back seat? That they then go to his friend's house, Frito Bang. You saw the picture, it states 62, they're hanging out. What are the odds that each and every single piece of evidence is stacked up trying to implicate him? And let's be very clear. There are attacks on Detective already on that. Asking he's trying to better himself or further himself. Detective Moretti testified he's a detective in the Homicide Bureau today, just as he was 5 years ago when this case occurred. To say that a man who spent 20 years in armed services in protection and furtherance of his country cares about publicity? There is no impeachment There was no articles or news things on that. No, Detective Moretti is here fighting on behalf of Christopher Thomas and Anthony Williams, the two young men, kids, that were murdered. And let's be clear, calling someone a kid, anything like that, is a play on your sympathy. And ladies and gentlemen, you agreed when we sat down for jury selection that sympathy would not come into play. That you would look and base this on the facts and the evidence. And ladies and gentlemen, I submit to you, you have that. Let's talk about some of the suspects quickly. First of all, they bring up that Danny Polo mentions that and taught you that what does on a plate mean. So let's be clear, Danny Polo's good to tell you and teach you that term, but when he says fire, you're not supposed to believe him. Which is it? You either believe or disbelieve. Danny Polo is a detective with tons of experience in this particular area. He talked about listening to wiretaps, reading all of these communications. They were talking about a gun. It's very clear from the context on that. But so then let's look at that on the plate comment. When did that happen in those messages? February 6th of 2019. So not anywhere near the date of incident. Again, another red herring to try and say, oh, this doesn't fit. And ladies and gentlemen, having a motive does not equal guilt. Having a motive does not equal guilt. One singular online statement is not the same as having the reasons and the opportunity and the means to commit this crime. And the only person who had the opportunity, the reason, and the means is this defendant. So counsel kept saying the presumption of innocence. That's gone. Once the evidence is there as to each element of the offense, there is no longer a presumption of innocence. Again, in jury selection, we talked about that. If it's illegal to have a certain colored pen on a certain day in this courtroom. Silly example, but a good point. It doesn't matter what color my shoes were or what jacket I had on. It's the elements of the crime, and only as to the elements that the state has to prove. And it's only beyond a reasonable doubt. As we discussed, beyond a reasonable doubt is not all possible doubt. We talked about this. We discussed this at length. That as a juror, if you had 100% positivity as to what happened, you'd be up there on the witness stand. There will always be questions. That's why it's what the puzzle shows. If you believe, and I submit that you should, the evidence from the testimony and the witnesses in this case, there is no question as to what that picture shows. That this defendant committed 2 counts of first-degree murder. So one of the things I want to make sure that you understand, ladies and gentlemen, is you will have the opportunity, because this has been many, many days. If you want to hear testimony read back to you, you're allowed. You don't get copies of the transcripts, but you can request any witness's testimony to be read back to you. Look at Adrian Davis's. Not once did he mention anything about a pee break. Never came up. If there was a reason, he could have testified to it. Where? When? No details. I can't even call him the one fact witness because what he's saying is not a fact. Because there is complete dispute as to what he is saying. So, counsel says that, oh, Detective, now Sergeant Chris Williams, was brought in just to pin it on this guy. No, ladies and gentlemen. Look at your notes. Think back to his testimony. What did Sergeant Williams say? Prove or disprove it was a drive-by. Not who was holding the gun outside the car, how far away. There was no testimony as to that. The testimony was what happened inside the car, what happened outside the car. And if there's no dispute that a murder happened, 2 murders, why all the cross-examination on meaningless details? Why? Ask that. So, again, we've talked about the phones, and even the defense counsel says the phones are reliable. They're that digital leash that we talked about, that you go back for when you forget it. And there's no evidence whatsoever that supports this, oh, the phone was left in the car theory. There's none. Phones don't send messages and walk 1,300 steps by themselves. There's no evidence whatsoever that anybody else got in that Jeep. What the evidence does show, the defendant was consistently in that Jeep, and that Jeep never stopped during that whole course of travel until it got to the edge of the Everglades. The edge of the Everglades, where there's no witnesses, where there's no cameras, where they can stage a crime scene to try and get away with murder. So, counsel talks about the verdict form. So, you're very there are options on the verdict form. Including a lesser included offense. What does a lesser included offense mean? A lesser included offense is the smaller felonies that make up murder in the first degree. So in this case, the lesser included offense would be manslaughter. That, as you learned from reading the instructions, is without the premeditation. That is negligently playing with a firearm and shooting someone in the back of the head. That's not what you have in this case, ladies and gentlemen. You have a planned execution of Anthony Williams, and then the same as to Christopher Thomas. Reasonable doubt is just that. It has to be reasonable. It's not beyond all possible doubt. It is one that has to, if you have a gut feeling that the defendant is guilty, you are not there on a search for doubt. That's not your job. You're to evaluate the evidence and determine whether or not the defendant is guilty in accord with the law. So, to go to that, and I'm stealing this from Mr. Howard's opening statement, jury service is not a group project. It is 12 individual opinions. So if you have been convinced beyond a reasonable doubt that the defendant is guilty of first-degree murder, you don't have to acquiesce to a lesser. If one person is not following the law and is not upholding their jury service, one person saying not guilty, that doesn't mean that's a verdict of not guilty. Mr. Adelstein answered that question for one of y'all during jury selection when he was asking questions. If you have an abiding conviction of guilt, the only appropriate verdict in this case is guilty of first-degree murder on 2 times. So, discussing as to reasonable doubt. We talked about it, about walking to work. Is it possible to walk here from Miramar if you live out there? Possible, but not reasonable. The simplest explanation that makes the most sense, that takes the fewest leaps, is that this defendant killed these 2 individuals. The why Don't have to prove that. But I've given you options, and the evidence has given you options. So, with regards to Mr. Glass, counsel talked about him. If Mr. Demons is at the house that morning,
Objection to the name.
Demons,
Right.
at the house that morning, and rode back with Travion Glass in that red Mitsubishi, why is Travion accusing him of doing it? Why is he saying in these messages, how would they ever think I did something like that? Why, if he was there and saw him now? So defense counsel talked about Brendan Collins. But I want to make sure it's clear for ladies and gentlemen that there's two different types of information. Brendan Collins testified that those other location points can be corroborated with other information. Surveillance video, things like that. So he's saying he's not using them because he's just doing the timing and things. Not that they aren't reliable, not that they aren't accurate, just that that's not what he uses. That was his testimony. In addition, counsel was trying to say that no, things can be changed because of the signal strength and it's things in between the phone and the tower. No, that is on the phone side, not the network side. This is looking at what the network sees when Brendan Collins is testifying. So ladies and gentlemen, you can go and you can compare the various evidence and the exhibits yourself. These will all be sent back with you as you deliberate. And you can look, for example, at the cash report, which is in evidence as State 65, right? This is the 772-713-9807 Demons phone. Well then, ladies and gentlemen, you can also look at what's been admitted into evidence as States 104. The drop pin. And don't take my word or the PowerPoint that I created to say that this works. Do it yourself. Line up the roads and see how everything overlays. Defense counsel says George Bello, his testimony is he can't give you an exact range or distance from that. And that is correct. He said that for a specific gun. However, it's different than what Sergeant Christopher Williams is doing. Because remember, George Bello is doing the internal ballistics of the gun, not the external, not the trajectories and the flight paths. That's not his area. That is separate and apart. Chris Williams is doing that aspect with the trajectories. In terms of all of the information from George Bello, there is still casings that match and projectiles that match on them. Counsel then argued that Kurt Rhodes goes back to the car to get DNA. No. As you heard, ladies and gentlemen, that DNA was collected October 26th of 2018. For the Montessori school, in the route and flying back, counsel says, oh, well, we didn't check traffic and weather. Well, then in the next breath, the argument was, well, it's 3 a.m. in the morning, there's nobody out. Just get out on the side of the road and pee. But there's no evidence to that. Look at Adrian Davis's statements. Look at his testimony. He never argued that. So for the search warrant on Jamison Francois, the 3 guns that are missing, the ones that all have the Glock back strap, the Glock, all of that, you know those aren't involved. And to say that the defense argument that the state or the defense or the detective does not want to find those guns is contrary to all the testimony from Detective Wright. If he didn't want to find the guns, why is he doing search warrants at these locations? If he didn't want to find the murder weapon, why are they diving the C9 canal? Why are they diving the lake behind Frito Bang's house? Of course they're looking for them. When you're looking at and saying, oh, he's a professional. Ladies and gentlemen, the message was very clear where he missed a show to have his hair braided. He told his mom it's okay. Stop being all upset. To go through a trauma like that, to shoot a video on someone's cell phone, and watch the cell phone video. I'm not talking about the Facebook Live one. I'm talking about the professional. They're using a cell phone to shoot a music video. This investigation went on for 5 years. Every lead was followed. Every warrant was written and then sent. The only person every piece of evidence points to is this defendant. Ladies and gentlemen, the state has proven beyond a reasonable doubt Jamell has committed 2 counts of first-degree murder. Thank you.
Thank you. Ladies and gentlemen, we're back on your instructions on page 34, 3.13, submitting case to jury. In just a few moments, we will be taken to the jury room by the court deputy. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict and to bring the verdict forms back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberation should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or of any other instruction I have given in this case, you must tell me by giving a note to our court deputy. Many of you have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those devices on your seats where they will be guarded by the court deputy while you deliberate. If you need to communicate with me, send a note to the court deputy. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any question, if I can, in writing or orally here in open court. During the trial, items were received in evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room with you when you begin to deliberate. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate the rules we all share. Ladies and gentlemen, I'm going to send into the jury room with you with the verdict forms. There's also going to be a computer which has been you are able to use to see any of the electronic items of evidence that are in evidence. So you'll have that in the jury room with you with the evidence, so you can view it if you, during your deliberations. Also, there may be items of evidence that do not go back if they have a hazardous material on, they're identified as hazardous. They don't go back to the jury room, but if you want to see any of those items of evidence, they'll be here in the courtroom. We have the gloves here in the courtroom, and they'll be shown to you. Just let us know through a note that you want to view an item of evidence that's not back in the jury room, and we'll make arrangements to have it shown to you. All right? At this time, I'm going to ask Ms. Beverly Mayweather and Mr. Patel if you just remain in the courtroom. The other jurors are free to go back to their jury room now. To commence deliberations, you can take your notepads as well as your jury instructions with you, and I'm going to verify with the attorneys that all the evidence is here, and that will be following the bailiff back into the jury room in a few minutes. All right? Thank you, ladies and gentlemen. You can retire and commence your deliberations. Ms. Mayweather, Mr. Patel, just remain here, please. You're not excused. You don't, unfortunately, as an altered at this time, you're not going to go back in to deliberate. We may or may not need you to come back. We have your information. So you're not being excused. The admonition I gave you previously remains in full force and effect. You are not to discuss the case. Don't form any opinion about the case. Don't allow anyone to discuss the case in your presence. There's certainly no research. There may be things in the media. You're not to look at those things. Just turn it off. All right? We very much appreciate the fact that you're here and willing to serve, but at this juncture, you're not excused. We'll hold your notepads here, and we're going to contact you if need be. All right, ladies and gentlemen? All right? Could you escort them out? Thank you. Yes. Just give your notepads to the bailiff, please, and she can secure those. Thank you. Let the record reflect the 2 alternates who now also have been excused from the courtroom. Counsel remain along with the defendant. Anything to discuss, counsel? No, sir. Mr. Devins? You need the restroom? You're more than welcome to use the restroom. We'll arrange for that with you. You like how everything went, the presentation your attorneys made? Satisfied? All right. Thank you.
We're not going to vote.
You're not going to be here, so you won't come back. Well, he'll be right downstairs if you need us. All right, so right now we're going to be in recess. Can you stick around for
Yes.
talk off the record?
Okay, he wants to stay. If you bring it back in.
Well, let him go for a restroom break now.
Yeah.
All right, y'all. It looking like it's in the jury's hands at this point. So I don't know. I feel like I'm feeling like it's guilty. It kind of haven't changed since I heard the medical examiner and the ballistic
Range or distance from that. And that is correct. He said that for a specific job. However, it's different than what Sergeant Christopher Williams is doing. Because remember, George Bello is doing the internal ballistics of the gun. Not external, not the trajectories and the flight paths. That's not his area. That is separate and apart. Chris Williams is doing that aspect with the trajectories. In terms of all of the information from George Bello, there's still casings that match and projectiles that match on them. Counsel then argued that Kurt Rhodes goes back to the car to get DNA. No. As you heard, ladies and gentlemen, that DNA was collected October 26th of 2018. For the Montessori school,